I believe the case diary has not been received.
Was mentioning is to wait until the matter is called up. Case there is not received, is not a mentioning to be done at 10:30.
Not sure.
10:30 is for matters you don't want to do, something, some adjournment is sought for. Do you understand? Case there is not available, we'll pass orders.
We are on interim lawsuit, so
So therefore, this mentioning is not to ensure that to arrange for your schedule, it is for the arrangement of the court's schedule.
understood.
All right. So 40 we are adjourning it today. When can you get the case diary?
Lordship, as from Central Lordship, it should make an interim action. After vacation, any visit.
14th of August,
Lordship. I agree.
interim bail to continue.
I agree.
Yes. Yes.
Lordship, in item number 31, Lordship, bail hearing. Improving finance objection, Lordship, that record may be called for Lordship. It is filed to the
Let the informant make the mentioning. Why are you making a mention?
Lordship, and.
You are for the informant.
Yes, Lordship,
Okay,
and for the employer, on behalf of the state.
all right. Kindly pass on the slip. You will get it.
Yes, sir.
The petition mentioned matter for listing on Friday, your Lordship.
What
Transfer
matter?
petition, the transfer petition, your Lordship.
Transfer petition will come next.
So next day is on 12th, your Lordship. Which is Monday, your Lordship.
It's fresh matter.
Fresh Monday, your Lordship.
Why at this nick of the time?
If I understand the closure, your Lordship.
9.
Lordship,
You
9.
want it on 9.
Yes, your Lordship, on Friday.
Okay.
I'm grateful, Lord. Yeah, I recommend item 51. Then maybe adjourn for the day. Consider our mistakes on.
51 at the request of Mr.
Yeah, I mean,
Ahmed,
on behalf of AU Khan.
making a mentioning on behalf of Mr. Yu Khan. Matter stands adjourned for 2 weeks. Is there any interim order? Interim order is any will continue.
Please then 15, item number 54.
Yes, Mr. Khattoria. Yeah, what are the instructions?
The instruction is my total strength of principal in custody is my 28 members. And out of which 12 are working as a principal and 16 posts are vacant.
So when are you likely to go for regular selection?
It is quite difficult to say right now. Normally, what we will do, we'll conduct the selections there for the entire state at a time. So,
No, but your appointment of the respondent is contrary to the rules.
yes, sir.
When it is contrary, then it has to be. You have to set it right. The incumbent cannot be given the benefit of something which is not contemplated in the rules. Mr. Professor. It is your case that
Yes,
earlier you came before the court challenging the rule, saying that it did not have any provision for persons with disability, which means you are aware that there is no provision.
There is no provision for.
You were not selected. Then you withdrew with a liberty that in the new rules, if it is not there, you will pursue the matter. In the meantime, you were appointed.
In the new rule, madam, they have amended and
But this selection is as per the old rules.
selection is as per the old rule, madam.
Because assuming it is not there, the provisions of the PWD Act will be applicable. But in that case, there has to be a proper advertisement, which was not done.
Not done. Earlier also, 3% reservations were there, now it is 4%, madam. So it, and being a reserve category candidate, my lord, even if today advertisement is takes place, my lord, I will be selected because I am the only person, the disabled person in the Kachar district, my lord, and qualified. my lord.
That is for them to say, they have not said that. And they will not know, how will they know? Once they advertise, they receive the applications only, then they will get to know.
How can you claim that he is the only PWD candidate?
That is his claim. He can claim anything.
And my lord, being, I'm maximum age limit, I will get also relaxation, that's newly correct.
We are passing orders interfering with your appointment.
In the meantime, my lord, I will be allowed to continue with the,
That is for the government. We cannot direct the government to say that you are not a selected person as per the earlier panel. You are not a selected person. The government has come up with a statement saying that they are not aware when the new selection will take place. I could have understood your prayer at this election being intended within a period of 2 months or so. That is not there. But setting aside the appointment of the respondent is not going to entitle you. Because you are overage.
But issue that yesterday also I have highlighted. When I filed a petition challenging her appointment.
That period, that phase is gone. You
But that-
can't go
yes,
back,
yes,
you can't go
but-
back there.
But I'm just trying to highlight the issue that at that point of time. When they misguided the court, lordship, and remember that the matter was also placed before the division bench, and there. The submission of the state respondent was quite different. What I'm trying to highlight that it is not
Para
my fault.
17.
It could be decided at that point of time
What is this?
Para 17,
Let him submit first. Yes,
that it could be decided when I file the writ petition, the delay is not caused because of my fault, it is fault of the state
all
respondent.
right, but we can put the clock back now. How can we put the clock back now? It is for the government to take a call that yes, in view of this, your age will be condoned, you'll be given in charge.
No,
We are not concerned with in charge, we are concerned with permanency. Regular appointment.
Lordship is correct, I am not contradicting on this point, but my submission is that when I approach this favorable court with a prayer, at that point of time, I was eligible. But it is
Very well, we
for
consider.
the state respondent, they have taken two and a half
We
years time.
will consider that, yes. What do you want to submit?
I want to place the paragraph 17, my lord.
Yes,
Because in case of similar situation, I'll not, would interfere.
that we may not be inclined to do because there is no certainty when this election is going to take place.
In my position, my lord, I will be out of the job because my earlier service I have resigned.
We'll pass some of this.
Lordship, I may be allowed to submit one line on that point. So knowing the fact that he is not entitled to be appointed as part of 2003 rule, knowing the fact,
She has been appointed by the department. She has been appointed by the department.
on
You
her,
have challenged the order of the department.
that is absolutely true.
So whether what was her understanding at that point in time in the context of the issues raised in the writ petition, it's not relevant.
Right.
Okay, her discourse.
Then we list for motion item 1.
And state the names of the councils.
May I please open?
Yes.
For 39 bail application, madam, people are arrested on 4th of May, madam. Affair at page 12, madam. 12 to 40.
Yes.
But change your two, madam. I accuse number 2, madam. The brand that accuse number 2, madam. And accuse number 1, madam, these worker, I am a contractor. madam. Only because, madam, I know him, madam. I have negotiated my debt with him, madam.
It's CDV Golfer along with EM,
Everybody was voted report, Worship,
EM report,
on, on 23rd of June.
23rd,
Worship.
this on 23rd of June.
Item two,
Page 11. The apparent is page 11. The allegation is that the miscreants were trying to stand sustained on the lady by doing illegal marriage. The three from the day of 6:30 AM, I was working in the Safari Fire, but two businesses like Golden every month. So we still came from Sangari and I'm working left side of the race to start. And they suddenly stopped near me, also by getting up a sweat. So that threatened me with a revolver. I mean, even try in the morning, workers able to capture one of the mistakes. I would like to mention here that 5 was collected. We did, collided with the car and captured mistake was the public morning worker for the mistake. I request to kindly to recover my check as is possible and release me from my. I was the person who fell down.
You fell down
I fell down.
while trying to snatch a chain.
The other person who was there, he did the same, he took up the revolver, he left. I fell down, I was.
He was on your bike.
Not my bike, it was his bike. My only condition is also the length of detention. I am
When were you arrested?
I was arrested on 14, but forward on 16, 4 to 10 according to me, it's 53 days. There was
Let city court be called. It's a 60-day offense.
60 days.
CD, you, it's
Short
from
day.
Janmari.
Janmar, voted a vote.
Janmari.
Janmar.
Yes, it's all
You have it on 12?
Yes, it will.
item three,
Your Lordship, I was solely arrested in a case registered under Government Police Station.
Change the chain.
Same.
Same.
I'm solely arrested, Your Lordship. I was solely arrested on 9/5/2023.
You're the person riding the bike.
No,
No,
no, in this case, I'm not involved, Your Lordship. Thus merely arrested on the basis of suspicion, Your Lordship. Because another incident occurred.
how come all these chain snatchers know you? You had heard Mr. Direct Counsel for the party for seeking. List on 12. It's also from Golumuk. Golumuk, isn't it? Golumuk PS. List on 12.
or
Post 39 bill application, the third application, Lordship may kindly peruse page 28 for 29 for a moment, Lordship. 71 days in custody, Lord, third bill application. Page 29, 11-month-old son, Lord, and the wife is previously in the certificate of annexation, page 31, Lord.
What was the FIR?
Lordship, FIR is page 13, Lord. It's a case of Marpit, Lord, 33 has been imposed, Lord, from the FIR itself transferred. With due respect, I like to inform you that schedule a group of 10 people have been attacking on the other informative source near the school. The group of especially attacked me repeatedly and took away my mobile phone, money bag, and cash amount of the school as well. 11 o'clock, 12 people is standing there.
What are the new grounds?
The illness of my child, my wife, and there is no one in the family to look into the matter. And
All right. CD required.
City Lordship, it's from,
particular,
Kavi Lambre, Lordship, very sorted, very little. Yes,
12,
Lordship.
all for CD, mixed on 12. Hang on.
Item number 5,
May please motions. In this case, 482 petition for quashing the proceeding in PRC case number 519 of the 21 pending before the learned CGM. In this case, what happened, my lord, an accident, motor accident matter, my lord. But in that case, my lord, the husband of the informant, my lord, that is, I have made party respondent number 2, my lord. Husband of the informant, my lord, is died. And the driver of the vehicle, my lord, that is the petitioner, my lord, driver. He has also sustained grievous injuries, my lord. But subsequently, after the accident, my lord, the on compassionate ground, my lord, both the parties are amicably settled, my lord. My lord, in this case, what happened, my lord, the driver also could not come from long distance, my lord, regularly. And that's why, my lord, quashing petition. And the next, the FIR, my lord, at page, my lord, page 14. And in this regard, my lord, the informant also shown an affidavit also, my lord.
Let the informant, actually serve notice, let her be present.
Yes, my lord.
Let the informant also appear before the court.
Yes, will appear, my lord.
Okay,
But in the meantime,
for the parties.
in the meantime, my lord, yes, maybe stay and
We should digest written number 4 weeks. This petition is filed by the petitioner seeking praying for setting aside and washing of PRC case number 519/2021 under section so and so pending before Court of CGL Boxa. In view of the fact that the informant namely respondent 2 in the petitioner have compromised the matter and put in effect deed of settlement has been executed by both parties. That by the informant before removing public. When is the next date? When is the next date?
it was so shortened.
When is the next date?
Next date, my lord. But on 19, my lord, 19.
19.
19, my lord.
You serve copies on informant
Obliged,
by Dusty.
obliged,
We take it up on 16.
my lord.
You serve copies, we'll take it up on 16.
Obliged, my lord.
Let then you make it returnable 2 weeks. Dusty is also targeted. It is submitted that the next date of the matter is fixed on 19. Therefore, this court is of the view that the matter be listed on 16 and for necessary orders in the presence of respondent number 2. Yes.
In the meantime,
It is on 19, we are fixing it on 16.
obliged,
You serve copies,
obliged, my lord. By registered post, my lord.
Dusty,
Or the justice, sir. Obliged,
registered as well as Dusty.
much obliged, lord. Thanks.
item 6,
May it please your lordship. This is a whole application lordship. This is case 9 lordship, case 9 lordship. Actually, case, as on case is pending in B lordship. My name is Jyotish Kolika lordship. Lordship, I was appearing from time to time, only a few dates lordship, I could not appear. Now, in this application, lordship, I have given the undertaking that I will appear as a when date fixed. Lordship, next date is fixed on 10/6 lordship. Today is 7/6 lordship. Lordship, this non-variable warrant issued against me, that this be recalled lordship. And I have given the undertaking that I will appear as and when date fixed lordship.
Yes.
I am very personal.
10/6,
10/6 lordship.
10/10, is it not a holiday?
Lordship, this 10/6 is the working days, lord.
Or working? Yes. Yes,
Yes, still then lordship NBW may be kept in administration.
heard the councils for the parties, this criminal petition is filed by the petitioner. So and so. Praying for setting aside of the order dated 3/4/2023, whereby NBWA was issued against the petitioner. Is what the council for the petitioner submits that in the matter of pending before the court of additional session judge, Kamrup Metro, session judge number 1, Kamrup Metro. Petitioner has been, petitioner is one of the accused,
Lordship.
one or sole accused,
One of the accused.
one of the accused
There are two
persons,
accused persons.
and he has been appearing in the matter on each and every day. However, because of some, why you did not appear in the meantime?
Lordship, due to some problems, lordships,
Because of some personal problems, he could not manage to appear before the court on a few dates. Therefore, the NBW was issued by the court on 3/4/2023. The learned counsel for the petitioner submits that he will appear in the matter and continue to appear on each and every day as directed by the court below. And as such, the NBWA issued the order dated so and so by which the NBWA has been issued. They interfered with and set aside. Learned APB and SH for and in council submits that petitioner be directed to appear in the court as the next date fixed is 10/6/2023. And I think our learned counsels for the parties. This criminal petition is disposed of. Directing the petitioner to appear before court of additional session judge number 1, Kamrup Metro, in connection with sessions LG 58. What is the case number?
Case number
58 of 2015, lordship.
2015. And he will continue to appear on each and every day as directed by the court below, directed by the sessions court. Also. If, as directed by this court, the petition appears on the next date fixed, which is 10/6/2023, the NBWA issued on 3/4/2023 shall be recorded by the additional session judge number 1, Kamrup Metro. Also. 10/6/2023, the NBWA issue shall be kept in abeyance. Criminal petition is disposed of in terms of the above.
Item 7,
For that is verification. So, order number 376. The FIR and case 10. Case 11. Nelly,
Yes,
Tamil submission is that the accused number 1 has been proven upon my daughter, name is so and so, as over 19 years, by making false promise to marry her. Since last 3 months, at present the accused number 2 and 3, by making conspiracy
that the accused number one is an unknown place, but has been saying that he has been missing. As a result, my daughter has been suffering from mental depression. With the accused number two, before you lodge it, how many said?
Who is he?
With the brother,
Elder brother. Yes, madam.
City.
Art, there councils.
Number three already released by this.
The petitioner before this court is apprehending arrest in connection with Jogi Gopal PS case number 131/2023 under section 376 IPC. Also, it is submitted that the informant, namely one Shahjamal Singh, had lodged the FIR making allegations against the accused persons that the accused person number one committed rape on his daughter by making false promise to marry her since last 3 months. Also, it was further alleged that the accused persons 2 and 3 by making conspiracy kept the accused number one at an unknown place and has been cheating by saying that he is missing. Full stop. As a result, his daughter suffered from mental depression. And accordingly, the FIR was filed. Learned counsel for the petitioner submits that the accused number 2 is the petitioner before this court. And accused number 3. The accused 3 is also the brother.
Three also brother.
The accused 2 and 3 are the brothers of accused number 1. And the allegation in the FIR is primarily against the accused number 1. And no allegation of the offense alleged to have been committed is made against the accused persons number 2 and 3. It is further submitted by the learned counsel for the petitioner that the accused number 3 had also been granted, who was arrested, has been released on bail by the order dated 25/5/2023, passed in bail application 1673 of 2023.
After perusing the case study.
Yes, APP submits that CD along with medical report and 164 statement we call for. Accordingly, let's CD along with medical report and 164 statement we call for. In the meantime, if the petitioner is arrested, it should be released on furnishing a bail bond of rupees 30,000 with 1 rupee security of life amount to the satisfaction of the arresting authority. Subject to the following conditions will appear. Within 10 days, will not hamper or tamper any evidence or requisite person to move out of the jurisdiction of Jogi Gopal case without written permission of the I. List on
8th of August.
8th, not 8th, 9th,
9.
9th of August.
Right.
What city.
Application, 14 numbers of petitioners for your lordship. Once we find the FIR case 22 months. This FIR is against us. We have also lodged an FIR. That is first in point of time. Lordship will come to the page number 22.
Yes, please read.
Where is the FIR? বিহিত নিবেদন এই যে আদি 10/5/2023 তারিখে রাতিপুৱা অনুমান 9টামান বজাত নিম্নলিখিত পদকীয়াগণে দলবদ্ধভাৱে চাপৰিৰ গুণ্ডা বাহিনীৰ লগত লৈ চকা অস্ত্ৰ লৈ পূৰ্ব পৰিকল্পিতভাৱে 1 নম্বৰ আসামীৰ নিৰ্দেশ মৰ্মে আমাক প্ৰাণে হত্যাৰ উদ্দেশ্যে আমাৰ ঘৰত অনাধিকাৰ প্ৰৱেশ কৰি মোৰ পৰিয়ালৰ বিভিন্ন জনক যধে মধে আক্ৰমণ কৰি জায়দা দেৱা আদি আৰু অন্যান্য দা আদিৰে কোবাই গুৰুতৰভাৱে জখম কৰে আৰু মোৰ ঘৰ মাটি বেদখল কৰি লয়। পিছত ৰাইজৰ সহযোগত সিহঁতক মংগলদৈ চিভিল হস্পিটেলত নিয়া হয় যদিও
আবু বকর সিদ্দিক আর কামালউদ্দিনের অবস্থা সম্পর্কজনক হওয়া হেতুকে গুয়াহাটি মেডিকেল কলেজলৈ প্রেরণ করে বর্তমান কেমত মৃত্যু হতে জুড়িয়েছে প্রভাব থাকে যে আসামিগণের প্রাণে হত্যা করে উদ্ধার বাহিনীর লগত 10 লাখ টাকা বন্দোবস্ত করার ভিডিও মোট হাতত আছে দিস এফআইআর ইজ এগেইনস্ট মেলর 23% মেলর out of this 23 40 is before your lordship মেলর your lordship will come to page 30 now. This FIR is used by us, madam, which is first in point of time.
Page number 30.
Page 30, madam. 30. Same allegation, sir. সম্মানপূর্বক বিনীত নিবেদন এই যে আজি 10/5/23 তারিখে আনুমানিক 9:30 বজাত পদকীয়াজনে পূর্ব পরিকল্পনা অনুযায়ী আমার মাটি তথা ঘৰত অনাধিকাৰ প্ৰৱেশ কৰি আমাক প্ৰাণনাশৰ চেষ্টা চলায় পদকীয়াজনে হাতত দা জাঠি জোং ডেগাৰ আদি অস্ত্ৰ লৈ বেদখলৰ চেষ্টা চলায় পদকীয়াজনে ঘৰৰ বেৰ বয় বস্তু সা সামগ্ৰী লণ্ডভণ্ড কৰে আৰু এটা চালি ঘৰত অগ্নিসংযোগ কৰে বেদখল কৰিব বিচৰা মাটিৰ তফচিল বৰ্ণিত শ্যামবাৰী মৌজাৰ মাটিটো পদকীয়াজনে বলপূৰ্বকভাৱে ৰাস্তাৰ নামত নিম্ন পদকীয়াজনে ঘটনা সংঘটিত কৰিছে পদকীয়াজনে চৰকাৰী বিগত সময়ত শিক্ষা ডকাইত তথা বিভিন্ন গোচৰৰ অভিযুক্ত ব্যক্তিসকলক লৈ আজি এই ঘটনা সংঘটিত কৰিছে বিশেষকৈ কিছুদিন ধৰি মাটি দখল বেদখল সংক্ৰান্তত এইসকল ভূমাফিয়াৰ উৎপাদত আমি অঞ্চলটোত থাকিব পৰা নাই সন্ত্ৰাসৰ পৰিৱেশ সৃষ্টি কৰিছে আজিৰ ঘটনাত জয়নাল আবেদিন চৈয়দ আদি লোকে গুৰুতৰ জখম হয় তো I have given my tag number, pata number. I have annexed the land document also, my lord.
What is your name?
My lord, in this case, my lord, Rasida Begum is the my lord. Rasida Begum is the wife of Abu Talib, my lord. Abu Talib is one of the my lord, petitioner, my lord. Abu Talib. So Rasida Begum lost this FIR. So my lord, I have given the detail, my lord, and I have annexed the land document also. They tried to my lord, grab my land, my lord. That is why there was a group fight, madam. That is admitted, madam. So they are the encroacher, they are some aggressor, madam. So that is why some scuffle between the parties, madam, took place, and some person of both the parties got injured, madam. So madam, my FIR was madam first, then they lost the FIR to madam as a counter blast complaint.
Your FIR was, both are registered on the same day.
Same day, madam. So my FIR was lost as a full of the case 136, madam, and their case 137. So, madam, so far as their FIR is concerned, madam, there is no specific allegation who gave the blow, who assaulted, madam. Simply said that at the direction of so one Jalaluddin, my lord, they attacked them and tried to grab their land. What is their land, or what is the tag number, what is the pata number? Nothing, my lord. I have given my all land document.
What is the name? What is the name of the informant in your case?
My lord, Rasida Begum, my lord. Rasida Begum is one of the my lord, lordship will find accused number 14 in their FIR, my lord. Taleb Ali. Taleb Ali's wife.
Yes, madam.
Lordship, it seems lordship on the FIR, there is a outstanding, there is a dispute between the parties.
Okay, let them, let us let the Kesdari call Malu with the injury report of both the Kesdari Malu. And till then, Malu,
Heard learned counsel for the parties. Petitioners before the court have filed the petition apprehending arrest in connection with Gula PS case number 137 of 2023 under section 22. Also, as per the said FIR lodged by the moment one Mukhtar Hussain, was alleged that the accused persons attacked and forcibly entered the house, the informant, with the intention of killing at the direction of the accused number one, and launched massive attacks on the members of the family. because of which they suffered injuries. So they were rushed to Mumbai Civil Hospital. And few of the injured were shifted to Guwahati Medical College. Critical condition. It is stated that the videos there are video photographs recorded by the informant. So Naral APP submits that case diary along with injury report we call for at the moment. Accordingly, that CD along with injury report in connection with Lula PS case 136
136
and 137 of 2023 be called for. Meanwhile, the petitioners are arrested. They shall be released on furnishing a big bond of rupees 30,000 each with one local security liable with satisfaction of the arresting authorities subject to the following conditions. They shall report before the IO within 10 days from today. They should not hamper or improve the evidence or influence any person or leave the jurisdiction of Lula police station without written permission of the court. And they shall not indulge in any illegal activity. Illegal or similar activities. During the currency of their pay. In the event, if the conditions are found to be violated, I use that we need to call for recall the interim being granted list on 11th August.
11th of August.
All right.
Item 9.
My lord, in this case, my petitioner is my lord, a victim of lordship blackmailing by some unscrupulous person, my lord, that with the nexus of police station, my lord. There was a nexus of the police station, police, my lord, with some culprit, my lord, the collection of money from himself, person of lordship. And my lord, that case, my lord, against my lord on Zulmoli Rava, there was allegation of the collection of 6 lakhs from a person of Lakhimpur, my lord. He was in the district of Nagaon, my lord, as IC lordship. Kindly see affair as a page 8 lordship. There is some, my lord, married lordship.
Please.
Yes. My lord, I have the honor to report that today on 5/5/2023 at 2 p.m. I received a source information about transaction of back Indian currency is going on at Borghat Udiya bypass number so and so. So above referred GD has been met and informed the higher authority who directed me to take lawful action. Accordingly, I along with SIP Manoj Borua, EPC Rafa Bunia, AG Sandro Bora, and armed forces personnel rushed to the spot. On arrival, I apprehended one Rashidul Hussain, alias Rashidul Haq, as it was so and so. I know the address is today, but no district Nagaon, Assam, and searched his body, but no any fake currency was found. During interrogation, he confessed that he, along with the following accused persons, were come to deal with the fake currency, but due to some misunderstanding, they were returned to their destination. Out of them, he well known one Faizul Islam, son of so and so, Nagaon and so and so district, Nagaon, and fake Indian currency may available in his house. So I, along with staff, accompanied with the apprehended person, proceeded to the house of Faizul Islam, and on being needed by him, search operation conducted after observing all the formalities of house of search under section 100 CRPC, and recovered the below described suspected to be fake Indian currency, which has been duly seized as per the list in presence of neutral witnesses. But accused Faizul Islam found absconding. During interrogation, he also stated that following persons are involved in counterfeiting the Indian currency note, selling the same as genuine among the people. This is the allegation, kindly see the names of the accused various persons are here, my lord. Total 9 persons, my name is at page 9, serial number 6. Lordship, he is from Lakhimpur, Lordship. The IO was, Junmoni Raghav was from Nagaon, my lord. My lord, there was, my lord, allegation, my lord, that is, my lord, is known to everybody, Lordship. That she collected money from Lakhimpur district while coming from, and she expired the result, my lord, that is under investigation, Lordship. My lord, that is under, my lord, cloud, Lordship. Now, what I am submitting, the petitioner is an innocent person, my lord. Some brokers are there, my lord, they, my lord, with the nexus of the police, my lord, police, Lordship, collected money, Lordship, from the different persons in Lakhimpur district, Lordship, and into, my lord, list was prepared, my lord. And suddenly went to the,
Let the CD come.
collected money, Lordship.
Let the CD come.
Now, my lord, some protection may be till then.
Let the CD come.
My lord, till then, if my lord, there something is in the CD, Lordship,
Can't be helped.
rejected, Lordship.
This is not just an open and shut case.
Lordship.
Let us have the CD.
So all of
With the-
protection of next day, Lordship.
No. Let us have a look at the CD. You are making allegations against the IO.
Interim, Lordship.
You are making allegations against.
My lord, I am not, ma'am. There is a, my lord, affair against our Lordship.
What
In
if-
another case, Lordship. That is I am submitting. My lord, I personally don't have any allegation, my lord. In the, my lord, what is in the,
These you were found with this Faizul Islam.
my lord, Faisal is not from, my lord, other.
So why are you named as an accused?
Well, no, I don't know, Lordship. My name is Bia Lordship.
Where were you?
My lord, address is 9 serial number 6, Lordship.
No, where were you?
Lakhimpur district.
Why are you named as an accused?
My lord, there is a some.
How is Faizul or any of the accused known to you?
Idol Islam, my lord, my lord, the IO does not say, the government does not say about Idol Islam, Lordship. Whether he.
So let us have the CD. Let us have the CD.
Now, Lordship, my lord, it is, my lord, there is a cloud, Lordship, Lordship.
I know it is coming from Nagaon.
She was from Nagaon, the government.
No,
was from Nagaon.
Case is registered where in Nagaon.
At Nagaon, Lordship, Lakhimpur, my lord, there are different district, Lordship. This is the, my lord, case where something, collection was going on, Lordship. That is why I am submitting, my lord, for some time, for time being, my lord, I may be protected, my lord.
Is there a bar for a person from Lakhimpur not to be available in Nagaon?
My lord, maybe lost, but there was a circumstance.
Let us have the CD. Give a short date.
On 16th.
16th.
No.
16th call for CD along with FSL.
My lord,
Money recovered.
myself for Lordship.
Money recovered.
No, nothing from my
Has anything been seized? Something is being seized,
Yes.
isn't it?
lord, seized from Idol Lordship, but
Correct.
my lord, is the affair.
So FSL may be available.
My lord, that
FSL is required.
Yes.
that is the clear, Lordship. What I am submitting, Lordship, it will take some time, Lordship. My lord,
Let us go through the CD first.
my lord, from the affair, my lord, you see that, my lord, if allegation is against me, Lordship, why the informant did not visit the house of the petitioner, Lordship?
We don't know.
Came back, Lordship.
That is what we
Came back
want
to
to find
the
out.
police station, Lordship.
That is what we want to find out. Give a shorter date. 12. Get it on 12th.
Lordship.
We'll see.
So Lordship, it will be difficult to, if we call for FSL, Lordship.
No, get the CD at least. We are ordering
FSL is also required, Lordship, because.
CD along with FSL.
Lordship.
List on 12th.
My lord, it say FSL is not come next day, my lord.
We'll consider.
Some of the.
Not necessarily, we'll consider. We'll consider. Why should we give an order that if FSL is not there, we'll give you interim pay? We want to see the CD. If the FSL is available, good. If it is not available, we'll make up our mind
Lordship,
on the basis of the CD available.
all right.
All right.
Item 10,
Yes.
The petitioner here is an advocate, Lordship, practicing in the Mohalla Bar and a member of the Mohalla Bar Association for last 23 years. Lordship. So they will come to page 12, Lordship, the higher range.
Yes.
I'm just reading what it is. The respectful submission is that I am Korobina, WPC 25 employed as women police at Pastorika police station, and the victim guard of case number 171-23 was produced before the court by me today. And when we came from the court, after completing the court work, a boy named Pushti Kalam took the victim Asana Kalam on his bike, wearing number so and so by this
causing physical assault upon me and tried to flee away. Thereafter, I apprehended the boy with the help of the police of PSI Court and Mohode Police Station and handed over the boy along with the bike at Mohode Police Station. It is to mention herein that on interrogation of the girl after apprehending her, she narrated that they tried to flee away as per advice of their advocate. The name of the advocate is Azad Ali Abdullah. Lordship, I am not the engaged advocate. Lordship. Actually, Lordship, what happened? This boy, Lordship, he is known to me. He talked with me in the court campus, Lordship. And he showed me the marriage certificate of the girl with his brother. Actually, the accused arrested in connection with 171.
If you are not engaged, why did you go through all the papers to give him advice?
No, Lordship, I have collected subsequently, Lordship,
Uh,
from his family members, Lordship.
all right, heard. Call for CD,
Lordship,
heard councils, call for CD,
I have protection, Lordship, that protection may be given you.
and 164 statement of the victim.
along with 164 and medical report. If any.
Because he,
In the
when he
meantime,
comes,
if the petitioner is arrested, he should be released on furnishing a bail bond of rupees 30,000 with one of the seriously like amount to the satisfaction of the arresting court. He shall appear before the IU within 10 days from today. And shall not hamper or tamper or with any evidence or interfere in the investigation of the case. He should not influence any person or witness. He should not move out of the jurisdiction of what police station is this? Order. Without without written permission of the IU. Let's begin on
11 to August.
11 August.
Item 11,
Field reservation. You will also in this case one, Tejusul Rahman, he was the loanee, and Arifur Rahman was the personal guarantor. It took the loan from PNB banks. Subsequently, that loan became NPA in the year 2013. And thereafter, an internal inquiry was conducted by the bank. And FIR was lodged by the bank. Now, the petitioner here, he is the advocate. He has been practicing since 20 years, and he was the panel counsel of the PNB. Now, before sanctioning of the loan, this opinion was forthcoming. And he opined on the basis of certain documents, genuine documents, that the land which was given in mortgage by Arifur is free from all encumbrances. Your lordship will find the opinion at page 20. Opinion of the advocate. The relevant portion will be page 22 last paragraph. Second last paragraph, in view of the above search.
22. Yes.
The line starts with in view of the above search. I hereby certify that the above plot of land belongs to Muhammad Arifur Rahman, son of Alizur, has been freed from all kinds of encumbrances, and the mortgager has a clear marketable valid title over the plot of land and is competent to create equitable mortgage subject to fulfillment of above conditions. So on the basis of the documents, like sale deed, original sale deed, Jamabandi, etc., he opined that the land is free from encumbrances.
Where is the FIR?
The FIR is at page 60. FIR, your lordship will not find my name, neither in the internal inquiry any whisper was made against me.
Then why are you apprehending?
Because the police has called me on white one notice under section 160 CRPC. That notice your lordship will find at page 28 for questioning regarding the mental health. Page 28.
Perhaps all as a witness.
No, regarding questioning in this matter, regarding the sanctioning of loan and.
Yes, madam.
Lordship. Let's see if there was a legal statement you could have filed.
Where is the,
Appeared already once, your lordship,
yeah, appeared once,
yes, on 18/5 I appeared.
Then lordship, civil lordship.
then why appearing?
Maybe protected.
Then no issue.
In the city comes.
No. We can, protection is all right, if there is a serious apprehension, unless there is an apprehension, you appear, when is the next day? When are you called again?
Next day, I'm not sure whether to take this.
You get your instructions, we'll see. Unless a person is apprehensive, why unnecessarily? It only complicates issues.
Because the police called me, that's why I went to.
Police called you appeared,
Yes, I appeared.
you appeared, that apprehension is gone.
Yes.
In fact, it may not be good for your client. Where is the FIR?
FIR page 16.
16. Is there anything against you?
No, nothing against that.
Be given an opinion.
And your lordship will find that in one analogous method, which have annexed, has annexed to page 29.
Hmm.
There the chief manager has already been contacted. Chief manager and another official of the bank.
Pertaining to the same case.
Yes, pertaining to the same case. Page 30, the relevant portion, first para. BIEO PS case number 5 of 2020.
When can you get the information?
Lordship,
Status,
status report. Or should we give us sorted immediately?
get it on Friday,
Lordship, on Monday, lordship.
Monday, we'll see on Monday. List on 12th, by which time the current APP MSSH Bora will obtain status report in connection with VIU PS case number 5 of 2022 under section so and so. In respect of, you'll only get a status report.
Lordship.
Mr. S. Dr. appears for the petition. Please take it on 12.
Obliged.
Item 12.
May I give you? The 30 regulation, FIR page 9.
Yes,
The regulation is under schedule 2 lordship and case number 1, 2, 3, 4 lordship already been arrested lordship. And 5, 6, 7 has been protected by this honorable court lordship. Petitioner the case number 8, 9 and 10.
8, 9 and 10.
10 lordship. The main allegation is against the case number 1, who has already been arrested lordship.
Who are you?
I am lordship. It is number 8, 9 and 10 lordship.
I know, how are you connected with
We are
the?
family members of the case number 1 lordship. Technical lordship, our name can be put in there. All are family members lordship.
You have attacked, that is the allegation. Accused number 1,
1 already arrested lordship. 1, 2, 3,
you are
4.
related to these persons. Accused number 1,
2
1, 2, 3, 4 arrested.
arrested lordship.
Yes, so you are related to number 2. He's your brother, number 2 is your brother.
Number 2 is the other lordship. That is the. Mofizuddin is our father lordship.
Hard Garden Council parties. This heavy petition is filed by petitioners apprehending arrest in connection with FIR. Lockheedpur PS case number 149 of 23 under section 27. By FIR dated 29/4/2023. Informant. One Regina Begum alleged that accused number one, named in the FIR along with the other persons, entered into the courtyard of the house and started to assault. Started to physically assault the petitioner. Informant's husband and son, causing grievous injuries. Also, they were shifted for treatment to Lockheedpur Hospital, but they succumbed to their injuries on the way. It is submitted by the Learned Counsel for the petitioner that the petitioners are not involved in the offences alleged. Petitioner number. The prime accused in the matter, namely accused persons 1, 2, 3, 4 have already been arrested. And some of the persons have also been granted anticipatory bail. Apprehending arrest, the petitioners have approached this court. Also, the apprehension is because they are related to the arrested accused persons. So MSSH Boral and the submits that case diary along with
Postmortem report.
PM report and 164 statement.
Yes,
Report for
and next date is fixed on 21/6.
this charge sheet has been submitted.
No, the other two accused granted bail.
Okay. 26,
21/6.
Page 19.
21/6, all right. Since the similar matter arising out of the same FIR is fixed on 21/6/2023, let this matter also be listed along with AB
Yes, Lordship.
1797 of 2023 on 21/6 calling for CD injury PM report and
Postmortem.
164. In the meantime, their arrested they shall be released upon furnishing with bail bond of fees. 25,000 with one more facility of bank amount, the satisfaction of the arresting authority. Subject to the following conditions. You will appear within 10 days. And subscribe to the other conditions.
Supplementarily, from motion item 53.
Yes, Mr. Zoma.
I would just put this.
Now, here what Manoj, I will not sit, I will take a lot of first, there are two FIRs, Manoj. And the first, in the first FIR, dated 15/2, he was arrested. By the next Manoj, yes, page 15. And after imprisonment manner, this court granted bail, there was the allegation of murder of a woman. And in the forwarding manner that I have given now, just to the lawsuits, in that there are two grounds of arresting the person. One is murdering the wife, woman, and another was the abandoning the child in Howrah system, 4 years child.
Abandoning it.
Well, abandoning the child, 4-year-old child in Howrah system. Howrah, Bengal. There are also is the forwarding, I am reading the forwarding manner. In that there are two grounds of arrest. That's why I will place a loss. There are also first page, there are also come to first, second, third paragraph. During investigation, the identity of the victim was found to be Bandana 3, DO, that was Chennai. The mobile number of the victim numbers was also recovered and was also done during the identification of the arrest accused. Investigation also revealed that one girl child named Madhusika was abandoned by the arrested accused in Howrah station
She was brought to Amingaon, accompanied by her parents for further investigation. Now next page, madam. Next page, madam. Channel number 4 and there are two files, 4 and 5. During exam of accused, so co-passengers of Rajdhani so from New Delhi to Guwahati, it has been found that that both the victim and her daughter were traveled together. Now, last fifth paragraph, the kid was also has also concluded that he abandoned the girl side at Howrah station, train station. CCTV footage showing the arrest accused and the girl side together at Howrah station have been collected, which shows that the accused had taken her to Howrah station and abandoned her. Now you have to handle of the second FIR now, on which I was sought to be arrested. In the first FIR, and a loss was granted bail matter, there is 13 of the petition now, 75/2023. Page 30.
Yes.
And after reviewing the CD, I am taking note of everything, my lord. Even the official report, the person was granted bail at the security of 50,000. In the FIR, everything was there. Now, my lord, second FIR, my lord, page 20. Page 20, my lord, relevant portion is 21.
What is that page 15? Which FIR? Page 15.
Page 15 is my earlier FIR.
What is the number of the earlier FIR?
Earlier FIR is my lord, page 15. Answer PS case number 58 of PS case number GB number
58 of 23.
58 of 2020. Now in the second FIR, my lord, there are 30th of
Page number
page number 21.
21.
My lord, the photocopy has been taken.
Yes.
With respect to the above, I would like to inform you that the IO of the during investigation of the transplantation also, it has come to light that the accused Lieutenant Colonel Amrinder Singh Walia, PRO, Defense Public Relations Unit, MOD, Tezpur, had not only murdered the victim, but also kidnapped her minor daughter, Marushika, age 40, from Sansari market on the prevailing night of 14th and 15th 2023. After murdering the Shri Bandana Sri, the accused kidnapped her minor daughter Mansuri with intention to conceal and confine her in the Sunsunsu quarter at Tandrapur and Philip Tezpur up to 21st February 2023. The minor daughter was exploited. This was new ground area now, and she was kept in the official quarter of Sunso with her for days. On 21st February 2023, the accused shifted the minor victim Marushika to Kolkata by flight again to conceal the confined victim to avoid police. Then with the intention of to exploit the minor girl, the accused took her to Howrah station, railway station, and abandoned for trafficking. Fortunately, the victim was rescued by members of NGO before any issue. But in the earlier FIR, it was the NGO, there was no ground for recovering the girl by the NGO. They are forwarding on which he was arrested. The CCTV footage showing the arrested accused person and the girl tied together at the Howrah train station had been collected, which shows that the accused had taken her to our station and abandoned her. Then the parents collect her. Yeah, the other thing is the.
Yes, Mr. Gogoi.
The same Mr. Malad, he was arrested and put him behind the bar. And there was not Malad, almost same allegation.
Two FIR lost minor. Again, there is some the same offense minor. Earlier, that was minor 30288, here minor
65.
and now kidnapping that 370 subsection 489.
Yes,
Yes,
for the.
but incident, same incident,
Same.
two FIR
Then
against same person.
why have you not
Malad,
asked for advice, but there are other means you could have approached the High Court. Questioning whoever.
this, the lots of more, how the kingdom of Troy was destroyed. Number, how the, and why the kingdom of Troy is love angle, mother, love angle is very
You
serious.
know, we are not on this love or hate angle.
Bengal, that minor, three, come back to 302.
Yes, that's what I am telling you. And kingdom of Troy was the.
One case is already pending.
Minor,
The earlier case, it is charges.
charging not charging. He was granted bail on the land of detention. In the ground of land of.
Has this FIR been registered?
Yes,
Yes,
number, number.
Chancery.
It is DRK number 644 K of 2023.
Heard Mr. R.P. Sharma, City Council assisted by Mr. Song. The Council Petitioner, Mr. P.D. Goyal, and the Deputy of the State. This anticipatory bail petition is filed by the petitioner. Apprehending arrest in connection with Chancery is case number 175 2023. Under sections 22. Also, it is submitted that earlier. And FIR dated 15/2/2023 was brought by the informant. Which was registered as Chancery PS case number 58/2023 under section 22. Where allegations of where it was alleged that an unidentified woman was found in a polythene bag on the roadside of Chancery, National Highway 31. Also, in connection with the same case, the petitioner was arrested and subsequently he was released on bail by order dated 17/5/2023 by bail application 17/5/2023 in PA number 1514 of 2023. Also, it is submitted by the Eternal City Council that in respect of the same allegation, a subsequent FIR has now been filed, which is dated 15/2/2023, relating to the same offences. Where is the new FIR?
New FIR case 21 mother.
Where the name of the petitioner has been specifically mentioned. There is no application praying for cancellation of bail.
No, my lord.
It is submitted by the learned counsel to the petitioner that in respect of the same offences, 2 FIRs have been filed. As such, he being enlarged on bail by order dated 17/5/2023 in bail application 1514 of 2023, connection with Changsari PS case number 58 of 2023. By filing the subsequent FIR dated 31/5/2023. The IO, the informant who's the additional SP crime, Kamru, has specifically named the petitioner in the FIR in respect of the offence alleged to have been committed by him. Also, where learned APP submits that CD along with BM and 164.
PM is not required, my lord, because 370 case, my lord, only statement of the taking minor error, my lord. That is required.
No, kindly see the first paragraph.
Idea case, my lord, yes, there.
No, first paragraph of the FIR, page 21.
21.
This is an allegation. Page 21.
That is, my lord, yes, my lord, in connection with my lord 58 idea case, my lord.
That is my default, yes.
Accordingly, let CD be called for. Also, you see that as on date, no application has been filed seeking cancellation of the bail granted earlier by this court by the order dated 17/5/2023 in BA number 1514 of 2023 in connection with Sanctuary PS case number 58 of 2023 under section. Accordingly, in the interim, petitioner shall be enlarged on bail if arrested in connection with in the interim, if the petitioner is arrested in connection with Changsari PS case number 286 of 2023, we shall be enlarged on bail upon furnishing a bail bond of ₹50,000 with 2 suitable local securities of like amount.
So it should be a resident of Haryana,
Then
Permanent resident of Haryana.
where is he posted now?
Successful manner. Earlier in earlier bail application manner, taken, then I will also order that he shall furnish the local security. That also.
Two individual, 2 suitable local securities of like amounts with the satisfaction of the arresting authority. And subject to the following conditions, it shall appear before the IO within 10 days. From today, he shall not hamper or tamper with the evidence, he shall not include any person or witness, and he shall not move out of the jurisdiction of he shall not move out of his present place of residence, namely Tezpur.
24, he have to come to Kamru manner. 24 Darang and Kamru. There, we have to cross to this things.
He shall not move out of the district of. Where is he posted now?
He is posted in Malor, Deshpur, but he is required to go to Delhi headquarters also. The earlier condition of 2 local security will do. Or by implementing the IO manner, they will.
He shall not move out of. You have not mentioned anywhere, where is he posted?
Yes, manner.
Where did you mention it?
That is the in the FIR manner is there.
In your petition, you did not think it was necessary to mention. Tezpur. Without.
In basic, Madam,
Without the written permission of the. Prior permission of the. Ayub. Page 6. Where. If any of the. If any of the. Conditions are found to be violated, it will be open for the Ayub to bring for cancellation of the interim data. List again on 11th August. 11th August. 11th August,
for evening, Madam.
No.
calling for CD. You will appear within 10 days,
Security amount, Madam,
50,000.
50,000.
You will appear within 10 days from today.
Available.
Bail hearing item 13.
CD is not available also.
CD available, not available,
Not available.
not available.
Yes.
38 days.
He was arrested on 12/3 also.
Matter 88 days in custody.
88. 88.
88.
So it should be-
Why CD not here?
We have to take instruction whether CS filed or not. Can be CS is not, is pending, no, CS 120.
All for CD along with PM.
Should mandatory period to be over by tomorrow, or should be after tomorrow. Then we'll take instruction again on tomorrow,
Friday.
Friday.
It's on Friday. You said 88. How many days? 88.
88 days.
Thought it was
Matter
58.
apparent coefficient has been
Day after
granted.
tomorrow, we'll take it up day after tomorrow. You
No.
get your CD if possible.
No,
90 days will be
all
all.
instruction was. All instruction was. If city is not coming, then we'll take instruction. whether
Today is 88.
Yes.
Tomorrow is 89.
89.
Day after would be,
90 days.
90
your
days.
right will commence only on 90 days.
Property certificate coefficient.
We are releasing it day after tomorrow.
If your lordship grant today also, 90 days will be completed in. Releasing.
I do not know, my limited understanding of the section doesn't say so.
But this is fourth time they could not produce the data, my lord.
We want a disposal,
It's mandatory.
On merit, we can do it.
To be open.
or if you're pressing the mandatory default right, then you have to wait for the period
Yes.
for which, before which you can't do it.
Not sure.
Length of detention can be considered a lot. And the FIR and APS person have been granted the exceptional value. And they are the FIR and APS number 1, 3, 4.
How do I consider in the absence of the CD in a matter of such allegation? Tell me that. Mainly looking at the order,
Present.
what kind of submission are you making?
Present. Petitioner himself victimized in this case. His younger brother has been died.
You are referring to earlier orders. What are you referring to?
No, but in. Your lordship has granted from interim.
Where?
Antiseptic value.
Page number,
Here also.
page number,
My lord, I have and letter on anger. I have annexed to FIR, my lord.
this is prior to perusal of the CD.
No, my lord,
Yeah?
No. And
but they are the FIR name is stable.
over there, those are anticipatory days. Very good.
This is after perusal of the CD.
No.
Fact is that matter. Two persons has been died. Both of them are good friends. One is younger brother of the present petitioner.
I am not the investigating officer. I do not know what is the fact.
Can consider length of detention.
That's what we'll do on day after tomorrow. That is, we're trying to make you understand. Unless you are not available day after tomorrow. We'll do it day after tomorrow, we'll take it up.
Item number 14,
Which they have done. Investigated.
I think otherwise also it's very simple matter, lordship, the matter has been succeeded. The charges already framed that was on 35 to 83 lordship, now the case is pending at the evidence stage. And tomorrow is fixed for evidence lordship, that is 8/6/2023. Lordship, we call for updated status report lordship. I have gone through the reports. Lord.
For the time.
15,
After two. It
Just diary receipt.
yes.
15. One page. One agreement.
Fast forward. Another page. CD receipt everything.
16,
Same results. Court opinion application lordship. Allegation is under section 382 of IPC. I am behind the bar since 37 days.
Chain snatching,
Yes,
Yes, madam.
right? What does the CD say?
Serious matter, no recovery matter.
Then
He has been arrested, near suspicion matter.
37 days, I am on suspicion, nothing is involved.
not recovered because he has sold it.
No, yes, and purchase the.
Lordship, in the FIR, Lordship, it is mentioned that the miscellaneous come by.
Your statement is there, although it is a statement before the police.
Participant is Lordship, further custodial interrogation may not be required, Lordship.
You don't know, let us see.
Moreover, Lordship, initial stage of investigation, Lordship, I have taken 5 days. Police custody, Lordship. So sufficient interrogation has done. Lordship. And I am local person, Lordship.
The investigation is going on.
Yes, that's it. They have to, my lord,
Yes,
they go
it
ahead.
has been sought for remand also.
I'll cooperate with the police, Lordship. At 7 days, Lordship.
Yes, Mr. Govind.
Now, that investigation, my lord, the part, my lord, yet be going on, my lord. And that recovery yet to make, my lord.
Recovery is sold it somewhere. How is
So somewhere, my lord, we should, my lord, go there and recover. That person, my lord, who has purchased the loopholes in.
That's why I have already undergone 5 days police custody. Whatever statement I have given already.
Why? You are under detention for 37 days.
Yes, sir.
So you want to come out and get back to your earlier actions.
Any condition will be given, Lordship.
No condition. Sorry, rejected. Third level councils, the parties. This AB petition is filed, this BA petition is filed seeking bail. The petitioner is arrested in connection with Kanmari PS case 120 of 2023 under section 382 IPC. As for the FIR dated 2/4/23, lodged by the informant, it was alleged that on 1/4/23, as she was about to enter the vehicle, Rajgarh Road, by the Baroda Bank, one scooty driver, young age, snatched her bag, fled away. One gold chain, one mobile handset, cash of ₹2,000. A broker's cloth, makeup set, lock and key, etc. were there in the bag. Pursuant to the investigation, the petitioner was arrested on one 5/2023. Since then, he has been in custody. Learned counsel to the petitioner submits that petitioner is innocent and not connected with the offence alleged. He was arrested only on suspicion. So this court by order dated 24/5/2023 before the CD. CD offer has been produced by the ABB. CD produced has been carefully perused. Upon the perusal of the CD, it is seen that the investigation is carried on, and charge sheet in the matter has not yet been filed. There are entries in the CD which suggest that further custodial detention of the petitioner is necessary as the investigation is not complete as on date in respect of recovery of the stolen items as well as arrest of other co-accused persons. Also, that part. Some incriminating materials are available in the CD. Considering all of the above, the prayer for bail is rejected at this stage of investigation. DA is dismissed. The case diary is returned.
17,
CD was called from, here CD not received from the number of PS one.
Let CD be called for.
That's what they're going to given, video for being,
19,
20 minutes.
20. Along with, along with, along with PM report,
Yes,
PM and FSA,
yes.
list on 20.
eighteen,
Yes, diary receipt.
The court attending the application with the petitioner is behind the court for the last 25 days on allegation of American to competition. Now to find a private place there. Husband of the informant commits suicide.
In respect of the same FIR,
Yes.
anticipated bail was also.
That is number one is the granted protection measure, who will see they are in custody. And in respect of that is number three.
As of date.
Yes, as of that, I will 25 days in anybody.
Here, madam, diary receipt without postmortem report. True suicide notice also there, madam, in the diary.
Why PM is not available?
Madam,
When will the PM be available?
from Pudia, working board.
There is no dispute that the minute committee. In allegation, the petitioner mentally harassed because
The dispute.
Money paid transaction was
Money paid.
there with them on them.
no dispute that they just come.
Call for the PM at an early date.
Yes.
When.
It's a matter that.
You can see, I think,
21, madam, 21,
21.
today's second.
21.
I will come early.
You have to collect good will.
19, let it be on 19.
19.
19. It is submitted by the learned APP that although the CD is called received, but PM report is called for as not been received. Therefore, raise for further time. Mr. Yazariga, learned counsel for the petitioner submits that he has been in custody for 25 days as on date. Therefore, short date be granted. Let the matter be listed again on 19 June. Enabling the learned APP to call for the PM report. CD received, in the meantime, be retained till the next date fixed.
Okay.
bail hearing every items 19 and 20.
FSL report was. Here, my lord, the diary we have returned it, my lord, now today not changed.
Learned APP submits that CD call for was
Diary from
returned for updation. Therefore, we seeks further time. Mr. P.D. Nair, learned counsel appearing for the petitioner, submits the petitioner is on interim bail. Accordingly, let the matter be listed again on 14th August, enabling the learned APP to call for CD along with what? FSL report. Then next, same similar order.
Lordship, I make lordship in that, for me, what of it in the bed between that may be taken up here, side the care lordship.
15, is there any CD available?
Yes, diary available.
She was arrested on. He was arrested on 2nd of May, lordship. And
Okay.
what I have been instructed, Lordship, the petitioner after completing the mission, she was pursuing some course here and in Instagram, she come across the girl and they had some intimacy. So on the very few days, we went, we just meet and already there was a trap and she has been the victim of a trap, Lordship. She has been in custody since 2nd of May, Lordship. And having no criminal antecedents, Lordship, belong to a very good and well, Lordship. Girl of 26 years, Lordship.
Any other person arrested? No, in connection with this.
Only they were my lord Facebook and my lord Instagram. Introduced themselves, but thereafter my lord on that day, it came to meet. Whether intention was my lord to kidnapping or not, my lord, that is not clear. But suspect that might be coming for kidnapping that girl, my lord, that is because
Nothing in the city.
yes, that is already.
Heard counsels for the parties. This a petition is filed by the petitioner, so and so who is arrested in connection with. Dispute yes. What is the case number?
Case number lordship,
Dispute yes
740 of
740
2020.
of 2023. Under section 366(511) IPC. By the FIR dated 29/4/23 laws by the informant, it was alleged that some unknown lady had come to the school to visit the minor daughter of the informant with the intention to kidnap her. So, however, with the help of the school authorities, the unknown lady was apprehended and handed over to the police. Also, the petitioner was arrested on 30/4/2023. And since then, she's been in custody. It is submitted by the learned counsel for the petitioner that the petitioner and the daughter of the informant had come to know each other through social media. And as she was in Guwahati, she wanted to be. She's from West Bengal.
And she's temporarily residing here.
Who will be her?
Local security cell here lodged. And he's staying at Nagaon lodged. She's having other relatives too.
She had come from West Bengal, and when she was in Guwahati, she wanted to visit and meet the daughter of the victim girl. So, daughter of the informant. Also, there was no other intention. Also, this court I earlier already did. So, call for the case diary, call for has been presented for this court. Today, upon perusal of the case diary, we see that the statement of the victim bill, the section 164 CRPC does not implicate the petitioner in respect of the allegation that she had attempted to kidnap the victim girl. Also, it was stated that they had known each other through social media. Although the victim girl did not continue to respond to the messages, continue to respond to the petitioner in the social media. So, the result of the case diary does not reveal any other incriminating behavior, which suggests that release of the petitioner at this stage of investigation will impede with the investigation. Lower other material is also seen from the city, who suggests that petitioner ought not to be released, that further custodial detention is necessary in respect of the investigation carried on by the police. Also, in that view of the matter, this court is of the view that considering the period undergone and taking the absence of any incriminating details in the CD, in respect of the petitioner at this stage of investigation, the bail petition is allowed. The petitioner be released on bail, on furnishing a bail bond of at least 50,000 with one local security of by amount, the satisfaction of the arresting authority. Petitioner will appear before the IO on each and every day as directed by the IO, and that she shall not move out of the jurisdiction of the IO till completion of the investigation without.
And this is the 429, the CGM Kamrup.
CGM Kamrup, and she should not move out of the jurisdiction of the CGM Kamrup without specific orders. But she will appear before the IO till completion of the investigation.
Apply.
Yes, disclose. See the return.
Items 21 and 22.
21, 22 started submitted.
Charge sheet submitted. It is submitted by the governor deputy. The charge sheet in the matter has been submitted. ID charge sheet number
145/2023,
145/2023 dated
25/4/23.
25/4/23.
Worship petitioners are on an interim to be continued.
The interim, the benefit of interim bail granted by order dated 11/11/2022 will be extended for another 10 days, enabling the petitioner to appear before the competent court before whom the charge sheet has been filed.
It is the lodge.
Same order in the second round.
23, 24.
23/24 diary not received.
It is submitted by the London deputy that CD Bob has not been received. Mr. AFNR. Submits that AFNU Mullah submits that they are on interim pay, therefore same be extended in the next day accordingly. This again on 14th August, calling for CD.
And 14, 24,
Similar orders. MS, your name?
people that are.
P. Purita appears to the petition. Based on 14 August. I go to 14 till 14 August. For seeking interim bail to continue.
25,
25 received diary received 306 case without FSL report.
Report for FSL.
Yes, that is
Let the FSL report is all from.
interim.
CD received the retained It is submitted by the learned counsel, Mr. Arhok, that petitioners are on equal pay. Accordingly, based again on 14 August.
26,
26 versus 30 submitted.
It is submitted by the learned David Nature. The charge sheet in the matter has been submitted by the charge sheet number
CS number 288,
288 of
22,
dated
19, sorry, 29, 12, 22.
dated 29/12/2022. Accordingly, the AD petition stands closed. However, the benefit of interim bail granted earlier by the order dated 2/01/12/2022 will extend for a further period of 10 days, enabling the petitioner to appear before the competent board before whom the charge sheet has been submitted and apply for regular bail if it's so advised.
27,
Yes, diary receipt.
Yes, 27.
Great pillars. But it will be the case while of regarding Muslim committee account while there are post market while in FIR, there are numbers of petitioners are named. Well, I am in connection with this number 391.
391. How many affairs filed?
Well, my case is this one on that date of occurrence.
How many FIRs were filed?
Madam.
How many
Two
FIRs?
affairs,
You are in the respect of the second FIR.
madam.
Hmm.
Well,
Yes,
our group filed FIR 391. I am in connection with 391.
are you named in the FIR?
Well, I have been named in the FIR, but my case is on the date of occurrence.
What is your name? What is your name there?
I am a teacher, madam.
Where is your name in the FIR?
FIR. I am giving my. Page 10, my lord. Number 3, my lord. Number 2,
Page 10.
son of Satekali. Page 10, my lord.
All right. Yes,
So, my lord, I am a teacher, my lord, on the date of occurrence. I performed my examination duty, my. It was on Friday. So that I attended the community prayer, my lord, and immediately I left. And thereafter, my lord, the market occurred. I did not participate in the market. Anyhow, my lord, FIR, the CBS come, your motion will look into city house. My name comes and how involvement has been shown. My case is this, my lord, on the date I performed an election, the examination duty, immediately performing that community prayer, my lord, I left the Mojiti campus. Thereafter, the market occurred. About 26% claimed in that.
yes.
Diary matter injury report, 3% injury report is there, madam.
And in the second FIR, my lord, 19% in India. So it is a gross market, my lord, regarding the account of the Mujib committee.
If regarding the account of the Muslim committee, there's so much of physical assault, what is the purpose of going to Muslim?
That is the thing. And that is also after performing namaz.
That was on a Friday.
And fighting started, person died also. This is the position.
Only because of accounts.
Accounts, that rival committee is there.
You should advise your clients to go digital. Maintain digital accounts.
Perhaps, my lord, after making the digital account also, my lord, this dispute will continue. There's some tampering with this attempt.
Yes, it
It is very unfortunate, my lord. I am a teacher, my lord. If something is there, my lord, I will tell this by. And I am on interim bail for a long time, my lord.
What is your name? Fazlur. What is your name?
My name is Fazlul Haq. Case 10, my lord. Serial number 3. Fazlul Haq, son of Sadiq Ali.
What is there in the pen drive? Some pen drive is referred.
That's it.
Some pen drive is referred.
Yes, we have not done to my lord, those pen drive.
Another aspect your lordship will consider, occurrence took place on 30/12/2022. More than about 6 months back. I have got sufficient time to inquire into the matter. I have submitted my identity card for the proof that I am on the site. At page 16.
Heard one councils for the parties. Please. This file by the petition of the leaders in connection with.
Place my lord that some persons my lord given bail my lord by your lordship. And
I did. But we will notify the informant. One is Zakul Islam. The state of Raj was alleged that on 30/12/2022 at about 1:10 p.m. while coming out of Montipara Mosque, performing Friday Namaz. Accused persons named were gathered there earlier. And there was an altercation between the accused persons named in the FIR as well as the relatives of the informant named in the FIR. Also, pursuant thereto, quarrel took place and the accused persons assaulted the other party with iron rod, dagger, and stick, etc., causing grievous injuries to them, and tried to kill them by knife. And tried to kill them. Thereafter, all the injured persons were admitted to the Nasikara Hospital. And some of the accused persons were referred to IRB Civil Hospital of Kokrajhar for better treatment. The present petitioner is named as accused number 3. This goes to this court earlier by order dated. Moving to 2023. Granted interim bail. The petitioners. The petition. The CD call has been produced before the selected by the judge. CD receipt has been legally produced. The only perusal of the CD is saying that there was a fight over the maintenance of accounts in the Masjid committee between two groups of people. Also, the investigations have been carried on, but charge sheet has not yet been filed. The careful perusal of the CD, no specific incriminating material has been found against the petitioner at this stage of the investigation. Incriminating material has also been found in respect of would suggest no incriminating materials have been found to suggest that release continuation of the interim bail granted will not be conducive to the investigation being carried out. Accordingly, this is believe that the interim bail granted can be made absolute in terms of the same conditions. And so the interim bail dated 14th June 2023 is hereby made absolute on the same terms and conditions. The petition stands alone in this proposal. Is that disposed?
My petition is allowed or
Your bail is made absolute.
after the election.
28,
What earlier operator lordship was the better lordship, their lordship was pleased to dispose of the case lordship. And after that lordship, that it is order continue order.
You know, a diary
They are
of
altogether Kumar Gita. They are altogether two more cases where their lordship in this earlier interim was there, so lordship was pleased to dispose of this case, made absolute lordship, and other two cases lordship were pleased to grant interim lordship because there was interim was not there. On our last occasion, case diary was there.
Yes.
and today diary is not available, madam. This is from before. Item number 28 and 34 both are same, arising out of same fact.
Okay. Then let it come after.
Then I have the submitted lordship because the lordship was pleased to dispose.
You are on interim. You're not
That
interim.
is why Lordship was granted to make absolute this one and other one where it was not there, Lordship was pleased to grant this. Because in the case that after.
The item number 28, there is an interim order.
Interim is there. Interim is there, Lordship. So Lordship was pleased to absolutely done.
I was pleased, but there is no order.
No order, but the computer also dispose of that. When we are finding it, we have got it from this person.
This matter.
Then why it is this thing? We should interim order. Continue. Oh, that is wrong.
Oh. When was it last listed? 21st.
Lordship.
So CD was produced.
CD was produced, Lordship. There is no violation of regarding the interim order, Lordship. That's why Lordship was pleased to grant, made it absolute. 31,500.
But it is recorded that up to date CD is to be called for.
But now there is no way. No. That may
We
be.
don't know, it may be because of some mistake here and there. May happen. We are not saying that.
I just wanted it almost.
But we go by the order which is recorded. Yes. At the request of Mr. D.B. Gogoi, London DPP, who raised for further time to call for CD, let the matter be listed in August. 16th August. Calling for CD, interim bail to be continued early. Interim bail passed earlier will continue. What is the next item?
Much obliged. 34.
You are appearing for 34.
I'm on interim.
Same. List on 16th August.
29.
Here, my lord, Churchill terminated. May please allow it. Here, my lord, we are on interim, my lord. We appear, our statement has been recorded, my lord.
Here we close it. We close it since the charge sheet has been submitted.
My lord, only my prayer is that, my lord, when my submission may be recorded, that we appear, statement has been recorded. It is my submission.
All right, Mr.
Diary is not available, my lord. We do not have it.
We'll record this submission.
We will submit.
Mr. D.B. Gogoi, London DPP submits that charge sheet in the matter has been submitted in the meantime. The charge sheet number
139/2023.
139 of 2023 dated
34/2023.
30th 3004 2023. MS
And Molly.
M. Malik appears for the informant. And Mr. S.M. Abdullah appears for the petitioner. Accordingly, this AB petition stands closed. And it is also submitted by Mr. Abdullah that the petitioners that in the meantime appeared before the IO and their statements were recorded. This AB petition stands closed and the benefit of interim order dated so and so will continue for a further period of 10 days, enabling the petitioner to appear before the competent board.
Likely 14 days.
Why? 10 days? 10 days. Enabling him to appear before the IO and file necessary applications if so advised. Not IO, sorry, competent board.
Competent board.
Yes.
30.
Currently, diary not received, my lord. Earlier, we once received a statement, my lord, to make it up to date.
It is submitted that his diary code for has not been received. For the way let the matter be listed again on 16th of August. Meanwhile, the interim bail granted earlier will continue. Mr. A.K. Doctor appears for the petition. 16th.
Lordship makes that.
16th August.
Yes.
31.
Somebody made a mention in 31, something. Some written objection. Yes.
I have proposed, interim was given, and I proposed with this matter, statement was recorded. Report my lord. So last two occasion, my lord, CD arrived, but medical report was not received.
Yes.
As per my information.
Same here, madam, today also CD received,
Without medical report and CD is also not up to date.
Yeah, my lord, as per my she denied my lord for the medical examination. And she always mislead my lord. First place today, she came with a written objection, my lord. Setting some new point, separately, separate observation, my lord. Today, she filed a written objection, my lord.
We call for the CD, let Mr. B.V. Gogoi learn it. APP submits. CD not received.
CD received, but not up to date.
Submits that CD, up-to-date CD is required to be called for, he pays for further time. In the same last CPS for the petitioner who submits that petitioner has been granted interim bail on 9/3/2023. And Mr. A.K. Gupta appears for the informant and an objection has been filed, which is based on report. Have you served a copy? Let the matter be listed again on 16th August. 16th August, interim bail to continue.
32,
Packet 2 and packet is staying out of stay in the yard. You want the candidate, you watched it, what I made in 11-4. Very clearly, you have the picture in the order.
What about CD?
11-4. My road, you was kind of say, in time was given, you was after going through the city. Paragraph 8 and 9, my road. Sorry, my paragraph. No, 5, 6, 7, 7 and 8. Basically, my lord, this receipt and the item of 93, that is the former supervisor position on he himself uploaded the video. He received my. So on that ground, you was what to consider it that way. Paragraph 8, 9, my lord.
Yes, CD.
Yes, CD received my lord, postmortem report, my lord, that it was due to SQ as a result of anti-mortem suicide case, my lord. And they are in him and appeared before the number 32 is ex-president, my lord, of the he is why is present president of Anchal Panchayat. Number my lord, 33, my lord, she is also my lord. She was ex-president, vice chairman, and now she is secretary of Congress. So the statements recorded, everything is there, my lord. He himself uploaded the particular video.
Has the video been examined?
Yes, my lord, that was a report is there, my lord. That was my lord proved that it was uploaded by the victim for the decision.
No, are they implicated?
No, my lord, that is the only whether voice was but that will not come, and that is probably. You also wanted to know who uploaded it. Yes, that was the question. He uploaded one of the how can we responsible for that? Who, if it is.
Who are you, Mr. Chaudhary?
I don't, I can partially through my lord.
Hmm.
He is a ex-president of GP. Now his
What
wife
is
is
your name? What is
My
your,
lord.
what is your name?
His name is Madam number Maula, Ghulam Maula.
There are two petitioners.
Yes, ma'am.
What is the name of the
One,
other?
other one is Dilwara, item 33. He is also my mother of three children. She is also present by the president of government, former vice president. Earlier, she was the president of the Our house is 100 kilometers away from the house of the deceased.
There are references of what, two videos,
Uh,
two videos,
Yes, yes,
one taken by him
yes.
while
That is my some words, my that is
In my additional.
additional application, my file.
Hmm,
Yes, beautiful, beautiful.
yes,
That is page 16, my lord.
additional affidavit. Where is your additional affidavit?
Which one? Which I got additional application. There is 15 or 16. So when did we find it? Oh, yeah. But that is the video of it. Just go simply stuff. Part class page 18.
Video.
No, that video is okay, but other than that, is there any other video? There is a reference, if you see in page number 2, paragraph 2. Of your additional affidavit. Informant's additional affidavit. Page number 15, para 2. There is a reference of some other video where he has been sought to be blackmailed.
And blackmailing.
Blackmailing.
Yes.
Where is the reference to that video?
That is another video, my lord. That is not here.
Then whether that video actually exists or not,
Video not circulated, on the detail of circulate the video, blackmail the. Item 32, there are 4 years, there is some relation between the. Deguara Begum and the. TV, there are 4 years, still number 3. In the application. Related to something. This Golan Mula. Directly implicated the Deguara Begum.
You have some video show.
There are 4 years.
Both parts of the problem met some relation. So video was recorded. Video was recorded.
And video was recorded by the.
This customer in
And that was the Anita.
Hmm.
And they also paid some amount.
So where is that video? You are saying that there is a video.
Right.
Where is that video? It is not there available.
Not published, it was not taken to publish. They let me know. If they publish the social media or any other, then I will not pay them.
You will not? You are for the informant.
Publish to others.
You are for the informant.
Yes.
Who, you are appearing for whom?
Informant.
Who is the brother of the deceased?
There are others.
So therefore, the second video, there is no reference here. Whether it is
They are not published or not.
You are appearing for the second matter also.
Both.
We don't know.
Delaware Begum is the name. Muhammad Mullah supported her.
What is your objection? Otherwise, you are objecting only in respect of one,
Especially Delaware Begum is main.
841, AB 841.
Yes.
Yes. What is your objection?
Delaware Begum and
The other matter, there is no objection.
other is the take-home of Delaware Begum. It supported the Delaware Begum to obtain the money. In video clip, only Delaware Begum and Vicky. Imamura supported that Delaware.
So you are referring to some video feed, blackmailing some video. Where is that video feed? Is not there.
On getting to publish that video, there was a blackmailing the Sikkim University obtained some money. Finally, when he came university, he also specialized to kill his work and get
Mr. Gogoi, Lordship, in the second video, there is no reference.
No, only one, but that is. Then only that is mentioned in the FIR, and blackmailing and money was demand, my lord, that was there. That is only. You get photograph taken.
State also the recorded.
Hmm?
State also the recorded one. That is what I was on that statement. And that video is not in existence.
While giving permission to the developer, publish of the, or even estimated developer.
Hmm?
On reason of publish the video version, they earn money. If the publish, they will not earn money. This is the draft. But if you commit to say, if they publish the video, they will edit in both.
Third, Mr. H.R. Chaudhary, the General assisted by Mr.
I use.
Ayu. Probably. Also heard Mr. P.D. Gogol undertaking for the state, Mr.
AAR for it.
A.A.R. Karim, appearing for the comment. These two bail petitions are filed. So you can take one by one. The AB 841. Sorry. 756. This was filed by the petitioner representing arrest in connection with an FIR dated 22/2/2023, lodged by the informant one Amir Ali Khan, alleging that his younger brother Azizul Haq Khan committed suicide by hanging in the rented house on Sadek Ali, situated in Junkaipara, Oslo. Before committing suicide, the deceased person recorded the video and named the accused persons as persons responsible, trying to blackmail him for money. And because of which the petitioner finding alternative has committed suicide. This court by earlier order dated 11/4/2023 and after interim bail while body for the CD. The CD report has been produced before this court by the undertaking team. The CD produced has been carefully produced. From the result of the CD, it is seen that matter is under investigation and the charge sheet has not yet been filed. The PM report immediately shows the cause of death to be because of asphyxia due to hanging. The statements of the various witnesses refer to the video which was taken by the deceased prior to taking his extreme step, where he made allegations against the petition also. From the reason of the CD, no such intimidating material at this stage of investigation is noticed to suggest that there is any involvement in blackmailing by the petitioner. The video recorded by the deceased prior to his death was also sent for FSL and a positive report in respect of the authenticity has been received. Also, the statements of the accused petitioner has also been recorded. Also, considering the extent of investigation which is proceeded with as well as in the absence of any specific materials that incriminate the petitioner at this stage of the investigation. This court is of the view that the interim bail granted earlier can be made absolute on the same terms and conditions. The interim bail granted on 14/4/2023 being therefore made absolute on the same terms and conditions. If the petition stands allowed to dispose of the CD return. So far in the second method is concluded. We write that the council has filed an objection opposing the grant of bail. Big part in councils and nothing television is there. You see that there appears to be some relationship between the case diary during the course of the investigation suggests some relationship between the petitioner and the deceased. However, no such materials are noticed from the CD, which suggests that grant of or continuation of the interim bail granted to the petitioner ought not to be continued. Full stop. No materials are seen from the CD, which suggests that the petitioner did not comply with the conditions mentioned in the order dated 11/4/2023 at the time of the grant of CD. Grant of interim bail. Considering all of the above, the petition stands alone. The interim bail granted earlier is made absolute on the same terms and conditions. The petition stands disposed of, allowed to dispose of CD return. Yes, disposed.
Already appeared, but the further appearance will be.
We have given, if required, will appear, subject to the following conditions.
Item 35,
Obliged. Hello. Hello, petitioner on intent matter, last of business, person asking, after, if you police on the medical.
Why not the liquidity report received? The only thing is that here the medical examination of Sri Ratul Sudhia. But in the petition, his husband's name is
Babu.
yes. Babu Sudhia. FIR it is written as Babu Sudhia. Because the medical is of Ratul Sudhia.
So you get the medical of Babu Sudhia.
Yes.
Then the DPP submits that medical report of one Babu Sudhia is available. However, from the FIR, it is seen that the person injured, stated to have been injured, and the husband of the informant is a person by the name of Sri Babul Sudhia. He therefore seeks further time to complete his instruction whether Babul Sudhia and Ratul Sudhia are one and the same person. Let the matter be listed again in the matter.
CDB also returned because CDB is last.
Further submitted that the CD, updated CD also be called for. Accordingly, based on 16th August, enabling learned DPP to call for updated CD along with the medical injury report. Injury report of the person stated to be injured as per the FIR. And Mr. A. Connigan, London Council for the petitioner, submits that the petitioner is already on the interim bail. Is taken on 16. Interim bail will continue.
36,
Report the read.
36 CD of the.
Mr. R. Kaushik, Lana DPP submits CD call for his non-dependency. Is taken on 16. Mr. S.M. Abdullah. Counsel for the petitioner, submits the petitioner is on interim bail. It is on 16
August.
16 August.
It will be continued. Obligement.
27.
It will be continued.
37 also sitting on plan. In terms of the interim petition appear before the IR.
Same order. Interim bail will continue. 16 August. 17 August. All right. 17 August.
38.
Submitted by Mr. R. Kaushik Nazar, the charge sheet in the matter has been submitted in the meantime by the charge sheet number
34/2023,
34/23, dated
dated 31/5/20.
dated 31/5/2023. The AV petition therefore stands closed. However, the benefit of the interim bail granted on 12/4/2023 will continue for a further period of 10 days, enabling the petitioner to appear before the competent court and file necessary applications if so advised. Mr. R.S. John appears for the petition disclosed.
39.
39 CD not received.
Mr. R. Kaushik submits that CD in the matter has been called for but not received and prays for further time. This again on 16 August, enabling the learned APP to call for the CD. Along with medical, nothing. Interim bail granted will continue. Mr. M. Ali appears for the petition.
41.
May please, 41 also CD not received.
231, 238 additional notice. Where it says one last applicable notice I have made submission. And you know, say the city is not come notice and then they will be considered. And others not there is the land dispute notice and then one more order I have added, then kindly come to page number 17. And there is the land dispute and two FRS.
Your named in which FIR?
Lordship and.
Which FIR? Which FIR? Dated? Page number?
12.
It is submitted by Mr. R. Kaushik that CD call for has not been received in the meantime, along with the engineering. Where is it coming from? Nearby, we'll call it. Then let it come on 12th.
I have some 11.
11 is a Sunday, we all have difficulties.
10 notice, sorry.
10 is a Saturday, working day. 10 is working.
13 notice,
10
13.
is working.
13 notice.
13. Could you look at 10? Could you look from there? All right. What's that? Order to be late. All right, we will, if Saturday is a working day, we fix it on 10. Saturday. Or on next available working day. You want it on 13, not on 12.
12% lordship.
13, all right, 13.
13.
13.
As per last order, the steps have been taken upon the respondent. But there is no stay, order the petition affidavit has been filed to bring in record the order copies. And the next step has been fixed on 26/2013 for ex parte evidence.
No, but answer notice has not been served. As per office law.
Yes, notice has been shared, but there is no stay in this case.
No, notice has not been served.
We have issued the notice.
We have done the.
You have taken the steps, but office note says answer notice has been received back. Means notice was not served. Refused, with the remark refused.
In this, in the lower case, lower court, there is no stay over. Where ex parte evidence has been fixed and PW waiting to put the.
Heard Mr. Desai, learned counsel for the petitioner and anyone for the state? No. Anyone for the state? No.
That is not.
By order dated 28/4/23, notice was issued in the matter, directing the petitioner to take steps by registered post-dating. Office note dated 3/6/23 reflects that answer notice in respect of sole respondent has been received back with the postal remark within post refused, return to sender. Accordingly, let the matter be listed for admission in the month of August. Meanwhile, further proceedings in DB case number 08
DB 08 of 2022.
of 22 pending before court of SDGM Bokajan, Sabi Road.
And another case, in this case, 07 of 2023.
DB case number 08 of 22 and this case number 7 of 22 pending before court of SDGM Bokajan, Sabi Road. Shall remain stay until August, until the next day.
43,
Released on 21st of August.
Okay. Regards registered post checking notice, the service report is not there. And that's the service, your lordship, we have not yet finally, we have not taken service over. We have not completed the service.
The learned counsel for the petitioner submits that dusty service is permitted. Has not been completed, therefore further time. Do you want to take dusty service?
Yes, sir.
So further time of 2 weeks is granted.
Can
Affidavit,
it be 4 weeks because petitioner is.
4 weeks,
there
4 weeks. Affidavit. Post dusty service. Be filed by the petitioners.
There is an interim on it.
Released on 21st of August till the next day fixed, interim order will continue. Interim order dated 2/5. Will be.
I think number 4 is
44.
44 is the same.
44.
Yes, sir. Same petition I am looking.
Why is it filed 2 matters?
There are 2 different criminal proceedings before the trial court.
Okay. Same order. Same respondent.
Yes, sir.
45,
Much obliged.
This is a review has been filed under low conduct ordinance. What has happened is, the company and we had settled a claim for 4,90,000. Over and above the amount already paid earlier, 2,39,000. Now in the order, it doesn't actually 490 minus 239. It should be actually 4,90,000. Because that amount has already been paid earlier.
I know the exclusive of 239.
So 239 paid.
Paid, and in addition, 4,90,000 has been agreed.
Okay. Over and above 239.
Over and above 239.
This IA has been filed. This will require change of the entire order. The order is, it is settled at 490
Yes, Councillor.
and 239 paid. So therefore balance 251 was directed to be credited.
Someone probably did not explain it properly.
We don't know.
213 has been paid. Because I have also different communication from the company also.
Regional
This can be a
manager,
part of the record.
regional manager of the insurance company is there.
Yes, sir. So this is they've advised me, the claim has actually been settled for 7,29,000. Out of that, 239 has been paid and 490 remains to be. That was the amount of settlement. Maybe while explaining lordship did not get.
You do one thing, there is a name reflected in the order, who is the regional manager. You get an instruction from her. In respect of
That
this.
is the instruction given to me by the company. I received this over mail. I have just prepared, taken a printed copy.
My lord, before, it was pre-settled in the office. In the office, it was settled 490. In addition to 239 already been paid in the lower court.
Learned counsels for the parties. This IA is filed seeking modification of the order dated 11/2/2023. Passed in the national. There's something wrong. Somebody somewhere did not mention it correctly because in the list availability shown as 490.
490 is the total settlement, but you see, the 239 which has been.
How can 490 be the total settlement? 7 something is the total settlement.
That is in addition to 239.
What I'm saying, so the total settlement is 7. 7, 8.
That is explained in the later.
No, but in the chart which is given, it is not there. Chart it is said it is full and final settlement.
Which is I asked for written communication from them, they have given it to me.
Let it come on Friday, meanwhile we'll get it verified through the office. They'll have some details. We are not disbelieving you. Let the details be placed in the, connected to the case record. Today is Wednesday, Friday we'll take it up. Alright? Let it be on Friday.
Alright.
Enabling the registry to call for the connected reports in the matter. Sorted out. I think what they are saying is that record must be. Yes.
Timing item number 14.
Yes, Mr. Vishwa.
Under this 413 application, my lord. 150 days behind the bar. And my lord, earlier I have submitted to the document. I have annexed the evidence portion also. But what happened, my lord, I take your lordship the FIR first, my lord. That is in page 12, my lord.
Yes.
With reference to the subject cited above, the informant begs to state that on 20th of December 2017 at 9:30 AM, the below named accused person entered into the house of my father, namely Abdul Mubin, and forcibly took out from home and badly beaten him by wood bottom on his head, as a result of which he sustained serious injuries. And my uncle Abdul Mujid came to here and tried to save my father. Then the accused person also assaulted him. After the occurrence, my father was taken to the Gajarkandi PHC, but considering the seriousness of my father was referred to the Tura hospital, and the concerned doctor of Tura referred to the Gwalpara hospital. And lastly, my father was shifted to the Jivan hospital, Guwahati. But on 21/12/2017, my father died at that hospital due to the injuries sustained by him. Provided that on 21/12/17, the informant went to the Kalapani outpost to inform matter, but the IC refused to take any action as the affair. Till that date, the dead body of my father is in Jivan hospital. It is therefore prayed that you will be kind enough to register the case against the accused person under proper section of law. And you will also find there are 5 persons named in the affair. And accordingly, my lord, this man was arrested and forwarded, my lord, today under 153 days, 58 days are behind the bar. He is even a case of charge sheeted, but trial has not yet started. Other accused are on bail. My lord, to my information, now my only thing is that whether your lordship consider the bail because after the charge sheet, that is to be point to be considered. Now, I am a local person, I am ready to cooperate with the trial, and there is no chance of flee away from the place of from the trial court, judicial trial court matter. Now, to take this matter to your lordship, I have placed 17 judgments of Supreme Court and our High Court and other High Court also.
Why is it come for orders? Or just passed over?
It passed over.
It's passed over, man.
Yes, last occasion, madam.
Yes.
You also asked me to place the judgment matter. I have placed the first judgment matter, that is a very famous case, Sanjay Chandra matter by CBI, where it was a very big case of India matter, the telecom matter, here I read out the important lines, paragraph, page 6, I have given some indication, page 6 number. Page 6, para 6, Sri Ram Jethmalani, learned senior counsel appearing with the appellant Sanjay Chandra, would urge that the impugned judgment has not appreciated the basic rule laid down by this court, that the grant of bail is the rule and its denial is the exception. Sri Jethmalani submitted that if there is any grant of bail, is the rule of denial is the exception. The Jethmalani submitted that if any appreciation of the accused absconding from the trial or tampering with the witness, then it is justified for the court to deny bail. The learned senior counsel would submit that the accused has cooperated with the investigation throughout and his behavior has been exemplary. He would further submit that the appellant was not arrested during the investigation as there was no threat from him of tampering with the witness. He would submit that the personal liberty is at a very high pedestal in our constitutional system, and the same cannot be meddled with the casual manner. He would assign the impugned judgment, stating that the learned judge did not apply his mind and give an adequate reason before rejecting the bail, as required by the legal norm set down by this court. The Jethmalani further contends that it was only after the appellant appeared in the court in pursuit of the summons issued, they were made to apply for bail and thereafter were denied the bail and sent to the custody. The learned, when I am coming to this other, see Jethmalani again. Jethmalani submitted that there is not even a prima facie case against the accused and would make reference to the charge sheet and the statement of several witnesses. He would emphatically submit that none of the ingredients of the offense
charged with were stated in the charge sheet. He would further contended that even if there is a prima facie case, the rule of still bail and not jail as per the dicta of this court in several cases. Sri Mukul Rustogi, the learned senior counsel appearing for the appellant, Vinod Goenka, while adopting the arguments of Sri Jethmalani, would further supplement by arguing that the charge earned in making the person who appeared in pursuance of the summons apply for bail and then denying the same and ordered for remand to the judicial custody. The Rustogi would further contended that the gravity of the offence.
What is the allegation here?
Yeah, but the telecom.
No, no, in your case,
In our, there is a case of murder.
murder.
But interestingly, if I go to the evidence, kindly come to the evidence, but I'm placing your lordship.
Evidence is 161.
Huh?
161.
Yes, yes. Kindly take trouble to come page number 47, madam, kindly. This is the one, Mamuran Khatun, madam. My name, address is same as I stated above. My occupation is housewife. On 28/12/17 at about 9:30, the accused Abdul Razzaq, Sirajul Haq, Suratul Bibi, and Rifazul Karim illegally trespassed into my house and started verbal quarrel with my husband in connection with the monetary transaction. And thereafter, the accused Abdul Momin attacked my husband with wooden bottom and hit on his head with force and thereby sustained grievous injury. My brother-in-law came forward to stop the quarrel, but the accused person attacked him and he also sustained injury. Thereafter, though we took him both of husband and the brother-in-law as Gazarkhan PHC for treatment, but my husband was referred better treatment for condition serious in nature, later treated with Hayat Hospital, Guwahati, but my husband died on 22/12/17. Then I take you to the next page. Page 49, come to page 49.
You are the name, you are the person's name.
Yes, yes.
What are your names?
My name is Abdul Razzaq and two other.
Number one.
Number one.
Abdul Razzaq, Sirajul and Suratul Bibi.
Yes.
What?
Yes, exactly.
There are four named accused.
Yes,
How many petitioners?
4.
Three. Three petitioners.
3 petitioners.
So what are their names?
Their names are Abdul Razzaq, then to Sirajul Haq and Rajibul Islam.
Rezaful.
Rajibul Islam.
Yes.
Then I take your lordship page 49, kindly.
Hmm.
Statement of the Abdul Majid. He was injured, madam. His brother-in-law. Own brother-in-law. The name and address as stated above is true. The deceased Abdul Momin and accused Abdul Razzaq are my own brother. A loan amount of ₹8,000 was due upon the deceased Abdul Momin, which he was supposed to pay to the accused Abdul Razzaq. On last 20th of December 2017 at about 9:30 AM, Abdul Razzaq came to the house of Abdul Momin and asked for the said money. But Abdul Momin said that he has no money with him at the present and he will pay the same. Later, after hearing the same, verbal quarrel started between them, and later an accused Sirajul Haq, Suratul Bibi, and Rijaul Karim also joined into the quarrel. There the accused Abdul Razzaq got angry and under sudden provocation, he hit with a wooden bottom which was lying near on the head of the Abdul Momin with force, thereby caused him grievous injuries to him. When I came forward to stop the quarrel, I was also attacked and sustained injuries too. Later, both myself and Abdul Momin was taken to Gazarkhan Hospital for treatment, but as the health condition of the Abdul Momin was serious, he was taken to Guwahati for better treatment. They are at Hayat Hospital. After getting treatment, while returning to home, he died on the way. That means he was cured. And he was discharged from the hospital.
That means he was on his way back and he died.
Yes,
He died on his way back.
yes.
It can only mean that. It doesn't mean he was cured.
Sorry, otherwise you would not have been discharged.
We don't know. The evidence says he got
Okay.
treatment and on his way back, he died.
what is my humble presentation to you, Lordship. Actually, without your matter, why you
It is possible that he may have decided to, the doctors may have said, better to take him home.
Of course, it may be either side.
It may be that go for higher treatment,
Yes.
better treatment, so many ifs and buts.
And
But
this is-
yes, he died on his way back.
Yes.
That is the statement. Now, what is the state of the evidence? No evidence.
No, no, no.
Evidence not taken, charge spread, my lord.
Why? When was the charge sheet filed?
Charge spread on 16/5/23.
So wait for
And next date was
Wait for
on
it.
30/5/23 for evidence.
Hmm.
I don't know my lord, what happened to 35.
So,
That is not in the record, my lord.
not there. These are the original reports.
Yes, yes.
Original.
No, no, yes, scan copy, scan copy.
That's right. Let us call for a status report. Let us call for a status.
But
report.
it is fact, my lord, trial has not yet started. So my, only our prayer is that before your Lordship, my lord, I am a local person, I regularly appear, and there is no chance of absconding. My lord. And my lord, I have to arrange my defense also, my lord. I am facing the capital punishment. My lord. And when the case is being.
In that regard, you point out the judgment.
Yes, the 164 step and all that. That is the in the record.
Let us call for the status report. Let us find out. And regarding the submissions in the, of the judgments that you have submitted, is there any particular judgment you want to refer to?
But our own High Court, I have given 3 judgments from what I do. And when each and the judgment of Supreme Court will show, my lord, that in a charge sheeted case, court has granted bail.
And there is no bar. Only depend upon action circumstances of people.
And the referrals I have given are more heinous crimes, my lord, they are committed. Finally, there is the country even.
What will be the effect on the trial if the person,
But I am confident that like,
what will be the effect? What will be the effect?
if I out on bail, we will cooperate, we will appear regularly.
I'm asking you a hypothetical question. What will be the effect on the trial
We will be acquitted, my lord.
in the absence of the person participating?
No, we will participate in this trial.
In the absence, assuming in a given case, not your client, some
No,
other.
if I don't appear, my lord, there will be the justice action of the court to bring me out.
What will be the effect on the trial? That's the question I'm
It will
asking.
delay.
Then
But I assure you,
you know the answer, I know, but you are delaying the, delaying.
But that I will give an undertaking that we will cooperate every day if required, we will appear.
Correct. So let us have the status report of the case. And we'll fix it up on a short date. Where is the trial pending?
And get this will be
Sounds of.
South Salmara.
south of one.
So let us call for a status report. Status report in respect of the trial being conducted before the court of session judge. Session judge. Before which court?
Session court.
Sessions court.
Yes, London session.
Then it's Sessions court. Sessions court, South
South
Salmara,
Samra,
Mankacha.
Mankacha. But I take your what is the evidence portion, is there not both the evidence you have to find that, was there anything?
Evidence, I remember one.
No, you get 161.
161, that is not evidence, that evidence.
In respect of PRC case number 344 of 2023. Perhaps renumbered now.
Yes, madam. Okay, ma'am.
Sessions case and renumbered as Sessions case 27 of 23.
Yes, madam.
Arising out of Mankacha PS case number 9150 2017.
Exactly.
Let the status report be furnished before this court in respect of the trial presently pending before the concerned court. On 14th,
Yes, sir.
14th June. Please, again on 12th date.
And all the judgment books I have given, very carefully. No problem.
Then Madras item 46.
Yes, Mayor, please. The four people for question, your lordship. Your lordship, out of some misunderstanding, your lordship, the respondent number 2, who is presently my brother-in-law, he lost an FIR on 37/18, page 10, your lordship. Immediately after 5 days, on 18/7/18, your lordship, page 14, may kindly see page 14, your lordship.
Page 14.
14, your lordship. The informant himself has written a letter to the OC for closing the FIR, your lordship. I then
What is the allegation?
allegation was that I have raped his sister, who is presently my wife. I have married her, we are having children, your lordship. Nothing survives, your lordship. I have to lodge the above mentioned FIR against Akhtaruddin. And it was not out of misunderstanding. Now we have mutually settled the matter amongst ourselves, and the marriage between Akhtaruddin and my sister have been fixed on 22/7/18. And as such, I would like to withdraw the above mentioned FIR for the peaceful family life. Thereafter, your lordship, we got married on 22/7/18, annexation 3, your lordship, page 15. Thereafter also, the informant again filed an affidavit, annexation 4, page 18. Annexation 3 is the couple number of our marriage. Your lordship, then
Yes.
affidavit, page, annexation 4, page 18. Your lordship.
Yes.
Thereafter, I filed the number of so and so against accused Akhtaruddin. Paragraph 3, that the victim of the instant case is my own sister who had love affair with the accused Akhtaruddin, which fact I came to know later on. That the alleged occurrence took place out of consent of both the parties. Consent. I filed the FIR out of misunderstanding. That subsequently the victim of the instant case, Hasna Begum, my own sister and accused, got married on 22/7/18. As per Muslim rights and rituals. So I am also annexed to judgment of this honorable court, which is annexation number 5 and 6. Your lordship. Nothing fruitful purpose will be served on the continuation of this. We have we married, we are living peacefully, having our children, your lordship.
You have the birth certificate enclosed.
No.
Yes, Mr. PPP.
Madam, here, offense is negative, madam, 376, is there, madam. Thereafter, madam, although he have committed, madam, agreement, affidavit, madam. But such type of offenses are not compoundable, madam, they cannot settle the matter, madam. There is several judgment and the Supreme Court, even victim cannot compromise the matter, madam. Here, the informant is not available there.
That's your problem.
I have elected judgment, this one, your lordship.
What are the elite offenses here?
And the informant himself has stated on oath. That
No, he was not just informant.
No, please come to the judgment.
So, what purpose? In fact, it will jeopardize their political life, your lordship.
Madam, informant is defined here, Hassan Ahmed is the.
No, he is my brother-in-law.
Madam.
He was
And
brother-in-law.
victim, madam, victim is not there, madam.
Victim is my wife. Abhishek is arrested 3. I will see the
No,
color.
I have seen, I have seen.
Different person. Your lordship under 482 has inherent power to interfere, your lordship.
Heard council for the parties. This criminal petition is filed by the petitioner. Saying for washing of
Dear Mother, PS case number 134, 2018.
the further PS case number 134, 2018.
Spelling year
457
1754.
under section 457/376 IPC. Charge sheet filed
No, the state, the better intelligence, no problem.
as well as the charge sheet. Dated charge sheet number.
No,
Charge sheet is not been filed.
no, because matter was state.
Madam, state.
But you-
Investigation must stay.
I mean, it was state.
Okay,
No further
so and so FIR. And further investigation in the matter also. Learned counsel for the petitioner has agrees that the informant had lodged the FIR. Initially, although the informant lodged the FIR, subsequently the matter was settled. As the petitioner has married the sister of the informant who is alleged to be the victim of the offense alleged to have been committed by the petitioner. Post of learned counsel for the petitioner is referred to an affidavit sworn, stated to have been sworn by the informant by affidavit dated 28/11/2018, whereby it is stated that the victim is his own sister, and subsequently they were married on 22/07/2018 as per Muslim rites and rituals by Muslim marriage register and Kaji Ratabari Karimganj certificate dated 27/08/2018. Where is the certificate?
Election 3, your lordship. Coming number 50.
And the council for the petition has referred to a photocopy of the this is the register.
Yes,
Is there a certificate?
no, this is the copy now, copy number is. And it is issued by the registrar.
Extract of the marriage certificate of slash Kabinama as per the details entered into the register of maintained by the Muslim marriage register Karimganj. Muslim marriage register by Ratabari. Which locality? Ratabari.
Karimganj.
Is it Karimganj or Ratabari Karimganj?
Karimganj.
As per the same particulars entered into the register, it is seen that one Aftaruddin is shown as the bridegroom. Aftaruddin is son of Abdul Sukur, late Abdul Sukur, is shown as the bridegroom, and Hasna Begum, daughter of Abdul Karim, is shown as the bride also. Learned APP submits that the allegations made in the FIR are serious, and as such offences cannot be compromised by the parties by mutual agreement. Having heard learned counsels for the parties, have been heard, pleadings available on record have been carefully perused. It is seen that there is an affidavit filed by the respondent number 2 stating that the matter has been compromised, and he has no objection if the FIR is quashed. FIR and subsequent proceedings are quashed. So the affidavit is stated, shown to be sworn in on 28th of November 2018 before Notary Public. Extract of a marriage certificate / Kabirnama is also available at NHL 3, showing the petitioner as the bridegroom and one Hasna Begum as the bride, who is stated to be the sister of the informant and presently wife of the petitioner also. It is further submitted by the learned counsel for the petitioner that the child has also been born of the wedlock between the petitioner and the sister of the informant also. Judgments rendered by this court order dated 9/11/2016, passing criminal petition 694 of 2016, as well as order dated 3/4/2017, passing criminal petition 940 of 2016, has been pressed into service. Upon due consideration of the arguments, as well as the pleadings available, and also upon perusal of the judgments and orders relied upon, this court is of the view that while there is no dispute that heinous crimes having heinous crimes against society cannot be compromised, the fact remains that the petitioner and the sister of the informant, who's alleged to be the victim, has in the meantime been married, and they are continuing their conjugal life as husband and wife. And it is also stated that the child has been born out of the wedlock. Full stop. The office note reflects that notices on respondent number 2 has been served. However, none has appeared. on behalf of the respondent number 2. In spite of notices being served. In this court, while issuing notice by the earlier order dated 12/12/2018, had suspended the further proceedings in respect of Nilam Bazar PS case number 134 of 2018 against the petitioner, and which interim order was extended from time to time and is still in force. Post of considering all the above, this court is of the view that in the peculiar circumstances of the facts of the case, continuance of the proceedings, investigation pursuant to Nilam Bazar PS case number in respect of Nilam Bazar PS case number 134 of 2018. Is seen not conducive in view of the fact that the petitioner and the sister of the informant have already married and have carried on their conjugal life till date. And the child has also been born to them. Accordingly, this court allows the criminal petition setting aside washing the FIR dated so and so, which is received and registered as Nilam Bazar PS case 134 of 2018 under section so and so. And all further proceedings carried there. Criminal petition is accordingly stands allowed and disposed of.
Much appreciated.
47.
Hello, previous case services complete manner, my senior, Mr. in his case, manner, I think not today like it, and for some reason, he might not be well, and for last year also was absent.
Who is the
Srinivasan. Srinivasan.
there are two counsels. Let the matter be listed for admission.
Minor it can be. But the majorly critical is.
We submitted that respondent is represented by counsels who have already entered appearance. Accordingly, the matter will be listed for admission.
Minor.
After 2 weeks, interim order passed will continue.
Let's move.
48.
It is submitted, the respondents are represented by counsels, however, none appears for the respondents on the matter being. Accordingly, this for admission.
Let's see.
Yes,
May I please watch it? So transfer petition will appear. The support of 7 square this week. There was a PRC case number 184 of the 2020 pending before the Munsil number 4 at Guwahati lawsuit. Results. Where the lawsuit.
why you want to transfer it to?
So transfer because of the I have to draw lawsuit attention is that case 16 in lawsuit. That's why may I read you lawsuit? In Banditoga.
Why is it for orders? Can copy received, not received. Can copy is called for, has not been received as per office note dated 31/5/2023 registry to issue reminder. List after 1 week,
Lawsuit.
Mr. Devan appears for petitioner and Mr. El Kashi appears for the respondent. Mr. Sharma appears for the state or some respondent number 1. List for admission.
Like
49.
The matter has already been accepted.
It is submitted by Ghana Council for the petitioner, Mr. K. Mira. That the matter has in the meantime become infructuous. he has received instructions to that effect from his clients. Accordingly, he submits that the petitioner does not wish to press the matter any further. Mr. Purakash appears for respondent 2 and 3. Mr. B. Sharma appears for respondent 1. The criminal petition accordingly stands dismissed as not pressed. Interim order, if any, will stand negated.
50.
So this revision is again, the order, the government order dated 8/8/2022 passed by the executive minister in a 145%. We are challenging the order on 3 grounds. One, that the executive magistrate has exceeded the power that has been conferred under section 145 CRPC. Second, that the procedure which has been prescribed by the 145 president CRPC has not been followed. And thirdly, the consideration which has been taken into factor are not based on record. May I take your worship to the complaint, the non-FIR, which has been, which is the basis of execution of the proceeding.
Page number?
Page 12.
Yes.
I'll skip the first description and read the allegation. It starts with non-FIR complaints brief description. Non-FIR complaints brief description is that the first party Dilip Toloi appeared in the police station and by submitting a written application informs that since 2005-2006 he is in possession of 1 kata of land covered by 153 Toji Patta and tag number 733 of Moinapara Setia village part under Gogamuk revenue circle and is paying revenue as well as by constructing a house there. For the remaining 9 acres of land, a settlement has already been obtained, and during the process of settlement and construction of the house, the first party informs by way of a written application that the second party Vinod Kumbang, Putu Saha, Srimati Apali Pegu. Now, Putu Saha and Apali Pegu are before your lordship as a place. Creates obstruction in the construction. Upon inquiry, it is revealed that the possibility of struggle between the parties for the disputed land cannot be denied. Presently, in view of the obstruction of the second party about the construction of the first party, has created a ruckus between them, and the same has breached the peace and tranquility of the locality. Therefore, it is prayed before this honorable court that the proceeding under section 107-145 may be instituted and summon may be issued to the parties for obtaining bond from them for maintaining peace and tranquility in the locality for a period of 1 year, as well as to attach the disputed land under section 146, restraining the parties from entering into the disputed land. The application of the second party Vinod Kumbang and the application for the first party is enclosed here. Number one, based on this, a 145 proceeding was drawn up earlier. And in the 145 proceeding, summons were issued. We appeared before the executive magistrate, but we were not afforded any opportunity to file our written statement. However, our statements were directly recorded by the executive magistrate. However, the section 145 proceeding makes it very clear that upon receipt, issuance of summons, the parties have to be put to written statement.
Yes.
Well, I come to the provision, but I just briefly indicate the facts. Now, the lordship has seen, basically, allegation was that there was an obstruction done by the petitioner with regard to the construction which has been started by the respondent, the opposite party. So there is no dispute with regard to possession. Now, page 16. Is a report which has been called from the circle officer of the revenue circle, Gogamuk revenue circle. Now, based on this report, this report was relied on by the executive magistrate while passing the order. May I read the report, madam?
Page number?
Page 16, madam.
16.
Translated copy is page 18. For vernacular is at page 18. May I read it?
Yes.
Lupum Dole's name is recorded against the land measuring 14 lechas covered by tag number 736 of Moinapara, Setiagaon map under Borderly Moza. Out of 14 lechas of land under tag number 736 of the Land Advisory Board in its meeting dated 13/1/2021 settled 9 lechas of land in favor of Lapung Dole, and consequently thereof, under the Basundhara scheme, the land is converted to periodic patta. Patta number 564 of tag number 874 comprises of 9 lechas. As informed by the applicant since 2001, the 1 kata land is possessed by paying 129 number Tozi land revenue. It is to be mentioned here that while physical verification, it is found that one person, namely Kutu Saha, is possessing a portion of land under tag number 736 by constructing a shop house and running a business there. Your Lordship will note this part. The possession of the petitioner was acknowledged by the circle officer. So at the time when this proceeding was instituted, prior to the proceeding was instituted, the possession of the petitioner has been acknowledged. The copy of the sketch map is enclosed herewith. Lapung Dole's name is recorded against 14 lechas of land in the map of tag number 736. And Sri Padmini Kumbang name is recorded against 1 kata land under tag number 737, Moinapara Setiagaon under Borderly Moza. Out of 14 lechas of tag number 736, 9 lechas has been settled in favor of Lupum Dole, and later under the Basundhara scheme, the land is converted to periodic patta. Patta number 564 of tag number 894 comprises of 9 lechas of land. From the record, it is observed that Sri Padmini Kumbang has acquired settlement over 1 kata of land under tag number 736, and later periodic patta number 496 of tag number 785 has been issued. This is the report. Now, the respondent will be complaining. Statement at page 90.
Yes.
Since last 16 years, I am in possession of the land. There are wells and latrines constructed in the backyard, and there are 6 shops in the front side. Total land measuring 1 kata of land.
Where is the order that you complain?
Mine.
Where is the order?
Page 27.
Yes. So what has been granted by this order?
Mine. The executive principal has declared us, the petitioners, as an encroacher, saying that we are possessing the land without any authority. By virtue of this, the executive agent under 145 proceeding has decided the merits of the claim and the title. And accordingly directed for eviction from the disputed land. May I read the order?
Yes.
Page 27. Whereas Pelus, the police report forwarded to this court for trial in connection with non-FIR case number so and so. The police report made out of mount a prima facie case under 107-145 CFPC in between first party Lapung Dole versus Binod Kumbung, Kutu Saha and Apali Pegu in regard to 1 kata land situated at Borderly Moza in Moinapara Setiagaon in Tozi, tag number 736. Accordingly, to substantiate the claims of the party, a report from Gogamuk Revenue Circle officer has been called for by order dated 1st July 2022. The Gogamuk Revenue Circle officer forwarded his inquiry report on 18/7/2022, stating in all details along with the sketch map of the disputed land. The Gogamuk Revenue Circle officer found that 14 lechas has been recorded in name of Lapung Dole, and the land has already been converted to a periodic patta out of 14 lechas, which is situated at Moinapara Setiagaon. The inquiry report received from Circle Officer Gogamuk also reveals that some portion of the land has been recorded in the name of Lupum Dole first party under tag number 736 Moinapara, and has encroached illegally by Kutu Saha and is running business erecting a house. Your Lordship has already read the report. The report nowhere says that the Kutu Saha has encroached upon the land. It says that Kutu Saha is also possessing.
Possessing.
Yes. There's a difference between possessing and encroaching.
No. Okay. The report says Lupung Dole's 14 lecha is covered by 736.
736.
Kutu Saha is also possessing a portion of land under DAC 736. So you are trying to say that 736 that number may contain more than
More
40
than, more land. And the report also does not reveal that the land under 736, which Sutu Saha is possessing, is the land which falls, which has been settled in favor of the respondent, Lupung Dole.
No, out of 14 ledgers, what is the meaning of that?
Out of 14
covered-
ledgers.
Covered by so and so,
Madam,
land advisory board, 9 ledgers. were
Nine
given.
ledgers.
9 ledgers were given to.
9 lessons has been settled in favor of Lupung Dole.
Lupung Dole. And regarding your possession, there is no measure of land.
There is no measurement.
You have also not paid any revenue.
Madam,
Have you paid any revenue?
no, madam, because in the originally the land which we have purchased from Dilip Tegu, Jiud Patel and Mukhyanath Patel, madam, these are the Patel. We purchased the land by of a unregistered sale. And there in 2002, there was a dispute between the original
Now,
Patel.
against the order of this magistrate,
Madam,
there is a provision for appealing.
yes. And we can also come because we have challenged the jurisdiction that the executive magistrate under 145 cannot go into the merits and the claims of possession. 145 subclause 4 makes it very clear. May I just read?
You are agreed by the last paragraph.
Last paragraph.
Yes, who's for the respondent? What do you have to say?
This impugn order clearly shows that I am the owner of the 9 lessons of land.
No dispute with that. You are owner of 9 ledgers.
Okay.
But what is the measure of land under this 736? There is no finding, total measure. You are given only 9 ledgers.
No, total measure is measurement is 14 lessons.
14
9 lessons,
You are the owner.
yes, Lord.
Now 14
9
lessers.
lessons settled with me in the year 2005.
Okay, so out of the five
Rest
more
are
ledgers,
going to settle
5 more ledgers. Under whose possession?
rest 5 lesser is also my possession.
On what basis? Only 14, only 9 ledgers have been settled with you.
Rest of 5 lesser is going to settle with me. I have applied for.
But that is not evident from the order. Order is very clear, page 28, last paragraph. Declare possession on so and so big of land including 9 ledgers, which is presently covered into periodic pata in the name of Lupung Dole. So 9 ledgers in your name. Second party so and so encroach the land of first party without any authority. This finding has to be on the basis of some material.
And more particularly, Miller, he claims he is in possession, I claim I am in possession. Miller, if your lordship finds the statement of the complainant, in the last part, he also acknowledges that we have a shop, we have an electric connection, we are running a shop in the. So meaning there, Miller, we were in possession.
But why have you not filed an appeal if you agree?
Miller, we have challenged the order. Miller, on the ground that the
Order has not declared settlement. Order has
declared as enforcer and
in some way it has passed an order based on the report of the circle officer. So at best it can be a misinterpretation of the report. It is not an order of declaration of right title.
No, but declaring as encroacher and directing for eviction from the as an illegal encroacher. Like if your lordship kindly come to 145(4), subclause 4. What is the scope of adjudication under 145 procedure?
Yes.
145(1) state that
Upon being satisfied there is a case of 145, the court will institute a proceeding and will put the parties in detailed statement. We were not given an opportunity to file written statement. Next, my lord, subclause 4. This is very important. The magistrate shall then, without reference to the merits or claims of any parties to a right to possess the subject of dispute, peruse the statements put in here. The parties receive all such evidence as may be produced by them. Take such further evidence, if any, as he thinks necessary, and if possible, decide whether and any and by which of the parties was at the date of the order made by him under subsection 1 is in possession of the subject of dispute. So 145 doesn't empower the magistrate to go into the merit of whether I have a right to possess or not. On the date when the proceeding has been commenced, and on that date, who is in possession. And now, madam, the consequences is subclause 6, madam. If a magistrate decides that one of the parties was or stood under the proviso to subsection 4 be treated as being in such possession of the subject, said subject, he shall issue an order declaring such party to be entitled to possession thereof until evicted therefrom in due course of law, and forbidding all disturbances of such possession until such eviction, and when he proceeds under such proviso to subsection 4 may restore to possession the party forcibly and wrongly disposed. So if the 145 protects the possession, so if there is a dispute with regard to the title matter, they ought to have filed a civil suit. And that's the procedure of law where they can evict us by say declaration that this we are an encroachment and we don't have a right to possess them. In fact, my lord, I have also referred to an earlier order of the executive magistrate in a 145 proceeding, where in 2002 there was a dispute which arose between the landholders from whom we have purchased the land and the respondents with regard to same document. There it was declared that the possession, the landholder has the possession over that disputed land.
Yes,
The earlier one, in a dispute regarding the earlier one. Okay, so that was tag number 180. Now it is 736.
we remand it back, let the authority redecide the matter, give them an opportunity.
Yes.
In terms of the provisions of.
Otherwise, Lordship, Lordship. It was specifically mentioned, hence you were asked to appear before the court accordingly with relevant documents, witness and evidence, etc. without fail. They have not produced any documents.
Where,
Lordship, my affidavit of opposition, page 14.
why have you not appeared?
No, we appeared. Our statements
They have not
were
produced any documents.
we were not given to file written statement. Both the parties were called on that day, these statements
No,
were
but-
recorded.
Not even affidavit in opposition, page 14.
Page 40.
Page 14.
Ultimately, a report has to be called for from the circle officer to decide who is the owner, who is not the owner. Matter is disposed of, isn't it?
Yes,
Not pending anymore.
no, this is a final one.
I heard learned counsel for the parties. This criminal petition is filed by the petitioners 1, 2. Being agreed by the order dated 8/2022. Passed by the Court of Additional District Magistrate Dhemaji under section 105, 145 CRPC.
Case number 16 and 25.
In case number 16M22. Also. Where on an application made by the respondent seeking orders under section 107, 105, 145. Proceedings were initiated by the Court of Additional District Magistrate Dhemaji. In the same application, it was alleged that the opposite party therein, namely petitioners, including petitioners 1 and 2 herein, had encroached upon the land measuring 1 quota covered by OZ tab number 736 situated at Bordoloni Moza in Moinapara city of map. Also, in response to the application 5, the additional district magistrate MID called for a report from the circle officer. Also, the circle officer by the report submitted before the circle officer in response to the requisition made by the additional district magistrate submitted its report on 18/7/2022. The report is extracted as under page number 16 and 17. Well, notices in the matter was issued to the opposite party, namely the petitioners, including the petitioners hearing. And they appeared before the court. Also, it is submitted by the learned counsel for the petitioner that their statements were recorded, however, no opportunity of filing objections was granted to the petitioners who appeared before the additional district magistrate as opposite parties number 2 and 3. Also, upon due consideration of the matter, the additional district magistrate passed the following order, page number 28, last paragraph. Extract. They agreed the present petition under section. This is 482.
No, 397, 401,
397 and 401 has been filed. Also, learned counsel for the petitioner submits that the appeal order passed by the district magistrate is beyond jurisdiction as contemplated under section 107(145) CRPC. The learned counsel for the petitioner, referring to the report of the circle officer, submits that there was no finding that the petitioners were occupying the land of the private respondents. Also, under such circumstances, there was no occasion for the district magistrate to return a finding that the respondents, that the opposite parties therein, namely the petitioners therein, had encroached the land of the first party therein, namely sole respondent herein, without any authority. Also, the district magistrates, the petitioners hearing were declared as illegal encroacher, and they were directed to be evicted from their illegal encroachment. And accordingly, possession of the disputed land in question was decided in favor of the first party, namely the respondent hearing. And holding that the first party is entitled to the possession of the scheduled land mentioned. Until and unless evicted from due course of movement. There was a further direction, there was a further direction to the second party, namely the petitioners hearing, not to disturb peaceful possession of the first party and abstain from committing any kinds of breach of peace and tranquility. Also, there are learned counsels for the parties of next this court by order dated 21/9/2022 issued notice and till the next returnable date, the imbued order dated so and so passed in case number so and so was stated. Most of the same imbued order was extended from time to time and is still in force. The learned counsel for the respondents. The respondents have filed their objections opposing the claims made by the petitioners. What are your submissions?
And they were given opportunity to defend their case before they.
Have you filed any objections? No.
They filed an affidavit, ma'am, affidavit. And in the affidavit, they are mostly relying on the revenue receipts which they have, which was never a part of the record.
They filed an affidavit opposing the claims of the petitioners. The learned counsel for the respondent submits that they were given sufficient opportunity to support their claims by relevant documents. Full stop. However, they fail to support their claims or reduce any evidence in support of their claims. It is further alleged that the petitioners are influential persons in the society and they are carrying their business by constructing shops over the land which is owned by the sole respondent covered by DAG number 726. There is some other case pending.
No, no.
230M, what is that? Page number 35 of your affidavit.
It is the earlier question. They were told.
You enclose some order.
There was regarding the number 180, there is different.
And the learned counsels have been heard, pleadings on record have been carefully produced. The impugned order taken so and so will also be carefully produced. You see that by the report dated
18.
18,
7/2020.
18/7/2020,
22.
22, submitted by the circle officer, Bogamuk Revenue Circle. It is indicated that tag number 736 consists of 14 lectures of land. And the land advisory board in its meeting held on 13/1/2021 settled 9 lectures of land in favor of Lapung Dole, namely the sole respondent. And under Bokundara scheme, the land was converted to periodic Bhatta number 564 of DAG number 874. Comprising of 9 lectures. It is further stated that one more quota of land is possessed by the said person by paying 129 number of Rosie land revenue. Cost of the revenue, the certain officer on physical verification found that one person, namely the petitioner number 2 was found possessing a land under DAG number 736 by constructing a shop house and running business therein. How many lectures make one product?
Madam,
How many lectures?
20 less.
No, that's 1 bigger,
Sorry,
1 quota.
one lesser,
How many quota, how many lectures will be 1 quota?
100 lesser. 20 lesser, 20 lesser makes one kata.
1 bigger,
One kata.
1
Five
quota.
five kata is, five kata means one
One
bigger.
bigger.
That means 100 lesser.
So this finding that 1 quota of land is possessed is under what that?
That is not mentioned.
It cannot be, it cannot comprise of the remaining 5 lectures.
Cannot. In fact, the complainant also in his statement admits that the petitioner number 1 has a store nearby this store. So.
Also. The report was accordingly submitted before the district, regional district magistrate. Yeah. Upon due perusal of the report, it is seen that what was recorded in the report of the circle officer is the land, what was recorded in favor of the sole respondent is 9 lectures of land, which was earlier covered by DAG number 736, subsequently converted to periodic patta number 564 of DAG number 874, comprising of 9 lectures. It is also seen that in DAG number 736, there were 14 lectures. And after conversion of 9 lectures of land in favor of the respondent, there is a remaining land measuring about 5 lectures. Full stop. The further finding of the circle officer that 1 quota land is also possessed by the sole respondent is not supported by the description of the said land as to under which DAG number or patta number the said 1 quota land stated to have been possessed by the petitioner by the sole respondent is stated to have been possessed by the sole respondent. Also, the further finding of the circle officer upon physical verification is that the respondent number 2 is in possession of a land under DAG number 736 by constructing a shop and a shop house and running a business therein. Also, as such, there is no clear finding by the circle officer that the land in possession of the petitioner number 2 under DAG 736 is the land which belonged to the sole respondent. As from the same report, it is seen that DAG number 736 comprises of 14 lectures of land, out of which 9 lectures have been settled in favor of the sole respondent. Under such circumstances, the specific finding that has been arrived at by the additional district magistrate that the petitioners have illegally encroached the land of the first party without any authority is without any basis. Also, consequently, the further finding that the petitioners are declared as illegal encroacher and they should be evicted from the illegal encroachment is also without any basis. Also, that apart, perusal of section 145 reveals that the district is to proceed in respect of the claims. Now, is to proceed in the matter without reference to the claims or the merits of each party as to the right to possess the land in question. Also, the power vested under section 145 is to pass appropriate orders in respect of dispute concerning land or water where there is a likelihood of causing breach of peace. Also, the magistrate under section 145 is not empowered to declare the title and consequently declare any person to be an encroacher without there being supporting documents or proper evidence being adduced before the court. Also, any declaration to that effect is ordinarily required to be made by a court of competent civil jurisdiction, before which the parties may approach if so advised. Under such circumstances, this court finds that the imperial order dated so and so is beyond the powers prescribed under the provisions of 145. Is beyond the powers of the district magistrate as prescribed under section 145, while dealing with a proceeding under the same section 145 CRPC. The imperial order is therefore interfered with and set aside, and the matter is relegated back to the additional district magistrate body to pose a fresh hearing in the matter, and the parties to the proceedings will appear before the concerned authorities and file necessary objections if so advised, and the matter will proceed therefrom. The district magistrate is at liberty to call for any further report as may be necessary from the circle officer or any other officer under the revenue department. Also, the parties are to maintain status quo till any such orders are passed by the district magistrate during the course of the hearing. The parties will appear before the district magistrate along with a certified copy of this order on any 22nd.
Good.
Convenient?
Yes, sir.
22nd of June. No, sorry, 2020, yes, 22nd of June. Also, till 22nd of June, parties are directed to maintain status quo as on date. The district magistrate will be empowered to pass appropriate orders as permitted under the provisions of CRPC. Criminal petition is accordingly allowed and disposed of in terms of the above.
Item 52.
Highly visible.
Please, your lordship. Lordship, so your lordship, can you pass the matter for the JS my serious insults?
Scan copy. Scan copy. Receive. At the request of learned counsel for the petition, the matter deferred for 1 week.
The lordship may kindly fix for another date for hearing until the next day the interim stay may be done.
Why are you making your submissions in piecemeal? You make it in one law.
It's an
It should come for admission.
Admission, it may come for admission also, admission hearing.
Let the matter be listed for admission after a week. Interim order, if interim order passed by this court.
lordship, interim order will take it 11/4/23.
11/4/23.
Yes.
11/4/23. We'll continue till the next date fixed. list on. 20. Any counsel available for part 2 hearing matters?
Part two hearing based, item number one,
what is the stage of the investigation is state, I think. They couldn't see any interim order. So please find out what is the status of this case.
Right.
This is,
2010 with the
yes. We have the case number.
no matter. We have no reports.
You have no report.
No matter, 2010 with the we have to go through the
You take the note of the
Right.
case record from
Right.
the police case, all women's police case.
Right.
Um, Some charge sheet, etc.
Whether it is state or not.
No, it is not state.
No matter.
There is an order directing at the relevant point in time not to
Right.
arrest the petitioner. Order perhaps is going on. All women's police station case 7 of 2008.
Right. All of it.
Understood?
Seven of it, madam.
2008.
2000.
You can find out the status.
Right.
And come, let us know tomorrow or day after.
That's it.
None appears for the petition. Matter passed over the day, Mr. D. Sharma, I guess, for the respondent.
Item 2,
And a case for the petitioner on both, Mr. B. Sharma, case for the respondent, last over.
Three.
Now we call it, this matter is a part, is there in the part two. No separate orders need to be passed. We'll call it up again tomorrow, if time permits.